Some of the
Surface
six.
action has been stayed for last 2 years. It was very short matter. Also, kindly take it.
All
Any
matters are short
time,
for you.
any time. In the month
Wait
of
for,
January.
I have accepted some of the mentioning slips.
Yes.
Let some of the matters be disposed of. Again, I will allow. Please bear with me. Yes. Not now. Yes.
Order number 6.
My lord. 6, my lord. I'm for the petitioner. My lord, Mr. Joyanta Samuti is appearing on behalf of the opposite side. My lord, he has requested me if this can be fixed at 11:30.
11:30.
11:30.
All right.
Deep. I'll come back at 11.
Khade ho jao. Right, yeah, no. Which টান ফ্যানটা বন্ধ করুন না কিংবা Yes, call the list.
$51.
Pass over.
$53.
Pass over. You are appearing.
No, 53, I'm for the state respondents.
Yes.
Answering respondent is CSTC. My lord, the petitioner, my lord, asked for CPF to GPF, my lord. Your lordship was pleased to direct the managing director of CSTC to pass a reasoned order. The reasoned order was passed, rejecting his claim. Challenging that, my lord, this petition has been.
Who is appearing for the petitioner?
My lord, Gautam De. Mr. Gautam De.
Pass over.
55.
Pass over.
56.
Pass over.
57. 58. 59. huh? 51 and 53. 52. No, 53.
53. 53. You are for 53.
I am for the 53, Lord.
Yes.
It is what's on the
Oh. 53.
Oh, Nijan. Lordship, may please to pass an order in this matter, Lordship.
Can be.
Can be what?
Yes.
Yes, Lordship. Lordship, may please to come to page 73.
73.
Yes. Lordship, please to pass an order on last occasion on 10th of May 2023. The order operative portion.
73. Oh.
The read petition, Lordship. Operative portion at page 75, Lordship. Paragraph 7.
Yes.
In that view of the matter, this court directs the managing director of West Bengal Transport Corporation, respondent number 4, to consider the
What happened after that?
Yes.
An order has been passed.
Yes, order has already been passed.
Where is that?
There is at page 78.
You are challenging this order.
Yes, Lordship.
This matter was heard before by any bench.
Previous occasion, it was taken up before the Honorable Justice Rajsekhar Mantha. And his lordship was taken up this matter for more than 5 occasions. It was taken up before the Honorable Justice Mantha. And his lordship was pleased to direct us to file one supplementary affidavit. In this regard, the one notification already before your lordship in supplementary affidavit, that is the prior to the date of retire, 6 months prior to the date of retirement, if anyone give any application or the option forms was taken or the then he or she is entitled to get the pension. For that reason, hearing was taken up before the Honorable Justice Rajsekhar Mantha. For that reason, we have already filed the supplementary affidavit before your lordship. Lordship, please to consider.
Take this point before the authorities.
No, it was not on that occasion, not with us.
Then-
On that occasion, not with us. That notification was
How
not.
can that petition be challenged on a new document?
No, that
Did not place that document.
that
before
is not the new document. That is the of the 2001 notification.
Raise that plea before the authorities. The authorities did not have any occasion to consider that.
No. We have submitted that. We have
You have raised that point before the authorities.
but
Show me that.
with the section of with the rules of the 59, it was not raised. But we have submitted before the authorities prior to the date of 6 months. We have already submitted our application. That was raised. But that the
Show
but
me
after
that how it was dealt with. Show me that portion of the order, how your submission was dealt with.
prior to that, lordship may please to consider the supplementary affidavit once for a moment.
Page,
Lordship.
which page of the supplementary affidavit?
That the after the that is page 14 most probably.
Page 14.
Not served on me, therefore my lord, I will.
You are looking at the door for Mr. Bhattacharya.
No, not at all. No,
For his
brief-
client, he
no,
does
brief-
not bother about the senior lawyer.
No brief.
Leader.
Brief with me at that moment.
Yes, Mr. Bhattacharya.
But it is a case of my lord option to be filed whether they will be permitted, these persons will be permitted to exercise their option for coming under the pension scheme. They were in CPF, to be very popularly said, CPF to GPF. Now, there was a scheme, the statute provides that person before retirement of six months prior to retirement, they can enjoy their option. We have given a list that we have already applied for option prior to 6 months of the retirement. We have given a table. The court directed the respondents that you hold an inquiry and investigate it and look into it, whether this is rightly given or not, and it is lying in your record or not. If it is lying in his record, then as per the statute, they are entitled to pension. Why did not you give it to them?
When did you retire, Mr. Bhattacharya?
Long time.
So what prevented you from challenging that I have exercised my option on such and such date, I have retired, but you have not considered my claim
That is
and you have accepted the CPF benefits. Why did you accept that? Since you have
CPF
exercised
acceptance.
the option to come over to the pension
This has
scheme.
been decided by this court also in the larger bench. My lordship has seen the 3 judges bench judgment. CPF, all CPF amount, those who are accepted by the concerned employees, while they are given an opportunity to exercise option, they are to return it with interest. No loss is causing to them.
Is there any, does the scheme provide for that refund?
No, that refund was not also
Mr.
provided.
Bhattacharya, that example which you are given.
That also did not provide.
Bhattacharya, that will come if after retirement a scheme is introduced for the benefit of the retired employees. Then in that scheme, the question of refund will arise. If your case is that prior to retirement, I have exercised my option. If that is so, there was no occasion on your part to take back the CPF.
I
So
have
the
not.
question of refund with interest does not arise.
I am not applied for payment of the CPF.
You have accepted that.
That has been
Why did
transferred.
you accept that?
I have not accepted. It has been already online transferred to my account.
All right. So why did you not approach the court at that point of time? I was not willing to accept that. I'm refunding that. They are not accepting.
It may be
The
some
scheme-
delay, but it is a
The scheme which
pension.
you are talking of, that at the time of return, I will be refunding together with interest.
That was a scheme.
Those where the schemes introduced after the retirement for the benefit of the retired employees.
That is a scheme. Under the Education Directorate, well, there is a
So
scheme.
you have to show that this scheme provides
No,
refund
this is
of
not,
the interest.
this is something, my lord, which right has accrued to me to take the pension. You have denied me the pension.
When did you retire, Mr. Bhattacharya? What
All
is the
table
date?
has been given.
Date will be very relevant.
টেবিলটা দে তো তুই টেবিলটা কাল করলি যে রাখালি যেটা আমায় দিসনি নিজে রেখে দিয়েছিস
Must be prior to 2013.
Supplementary affidavit.
2008, 9, 10, 11 must be during those periods.
retirement is between yes long before 15
No. I'm giving, yes, prior to 15, 9, 10, 11, 12. I think.
no
those
no
are
no
the years.
18
Yes.
18 19 19 17 14 19
Yes,
17
14,
17
11,
so out
2009.
of
Mr. Bhattacharya, do you know the bank rate of interest at that point of time? On fixed deposits?
but I'm a problem. I let me make myself clear to your lordship. An affidavit is lying in your lordship's record. Well, where we have given a table. Here also, my lord, some person's name are there. Date of retirement is there, but it is not coming before the 6 months prior to retirement. This should be eliminated. Because the first person, date of retirement, the retirement in 2018, he opted after
All right.
retirement.
So
But only
according
the-
to you, you have exercised your option in terms of the pension scheme prior to 6 months of your retirement.
Yes, that is there.
So how that has been dealt with in the reasoned order?
No reason order has been given to me.
Yes. Reasoned order, you are challenging the reasoned order, Mr. Bhattacharya.
No, that order, this aspect has not been dealt with.
You have not raised that point.
This aspect was not dealt
You
with.
did not raise that point. You did not raise that point before the authorities. Must be so.
কোথায় বলা আছে এটা বল dealt with. But that reasoned order, 13th of July 23,
13th of July 23. Yes.
page 78.
Yes.
May I place it for your lordship?
Yes.
In compliance with the order 10-5, the Honorable Justice Hiranmaya Bhattacharya, the Honorable High Court, Calcutta, the authorized representative of the writ petitioner heard answer. In terms of the order of court, representation as enclosed so and so, the grievance of the writ petitioner as well as the representation of the is that the petitioner had not been covered by the pension scheme introduced by the employees, although they were entitled to opt for the pension, especially when no intimation were ever given, widely seeking option from the eligible employees. Similar grievance of the application in the can has also been appeared. It has been contended that the petitioners were mostly driver, conductor, and other employees, that they had no lack of knowledge, but they are roaming around West Bengal.
So, Mr. Bhattacharya,
That was not the issue
this is
here.
contrary to the submission what you are making.
Yeah, of course.
So here it was said
This point was not there.
we could not exercise our option for pension. This paragraph.
Of course.
On that basis, you approached the authorities. That
Court-
was your case. before
We
the
approached the authority, my
authorities.
lord.
Now you are taking a different stand.
I am taking a different stand. And this is, I don't dispute to that, but that fact was very glaring in the face of the state authority. They had the
All right.
fact, but my client had not the fact. But this,
ওরা নোটিফিকেশনটা বললো কিন্তু তার মেল এডিট
হুম।
এই লাস্ট 81 এ আছে
81.
Yes. এই যে 2001 নোটিফিকেশন নিল মেন এটা নিল না
There was a notification that has been mentioned, my lord, by them, page 81 of the set.
they cannot claim
There was, but second paragraph of page 81, it is dealing with. There is no doubt that right to receive pension has now been considered as a fundamental right by the Supreme Court, as pension is the property of the employees. However, when a scheme for pension is made applicable in exercising a employee's conditional option, conditional upon them opting for the same, and such option is not exercised within the stipulated time, they cannot claim the pension as a matter of right. pension is payable under the pension regulation 2001, which have been notified in the official gazette. Since the appellants chose not to exercise their option within the time frame stipulated in the pension regulation and as extended by CTC, they are not entitled to claim the pension under. So, admittedly, my lord, the authority is holding that within stipulated time, if someone had exercised an option, they are entitled to pension. And
Yes.
some of us has, my lord, given the option within stipulated time. That was our claim. If that is so, my lord, whether that can be waived, that can be denied. This issue are no further, my lord, dealing with the said issue. Reliance placed on the Badat and others supported the submission in a general evasive denial of fact should be construed as an admission is again no assistance to the appellant, even assuming that the circular of 25th July 2006 was not widely published by sending it to the various offices. Despite the other establishment of CTC, pension regulations were notified in 2001 in the official gazette under which the option was to be exercised within 6 months from the date of publication of the pension regulation. The time to opt has been extended in 2006, which fact was published in a newspaper of 25th July. Therefore, in our opinion, the appellant have no right to claim the pension.
Stipulated time কোনটা? এটাই stipulated time.
This was also extended in 2006.
Stipulated time. Stipulated time.
That you did not say in the authority.
আমাদের যখন বলে বললে তো মামলা আছে, বললে কি আর মামলা
যখন actual time অবধি বলবি না?
Yes.
Therefore, the fact admitted by both the parties that time stipulated under 2001 regulation, 6 months prior to retirement, and those who opt for the same, they will be getting the pension. And admitted, ballot, we have also ballot, given the details that these persons have opted within the stipulated time.
Show me that.
Yes.
supplementary.
In the supplementary affidavit.
Yes.
Page 4.
So, আগে lawyer কোথায়?
You are for the state.
I'm for the state. My learned friend is the answering respondent.
Yes.
Learned friend was asked to verify whether actually we opted or not. Well, that answer she is supposed to give today. Right.
এটা সাথে এটা কি আছে? গোপালচন্দ্র
In supplementary affidavit, we have that. In the supplementary affidavit, my lord Gopal Chandra Mondol, at page 4, we have given the table and
Page
support.
4.
Page 4.
entitled. When is he retired?
Yes, show me the document that
Sorry,
you exercised your option.
I am screening it. It shortlisting will be there. Not all the persons are not entitled.
Yes.
My case is 2
From
four
this list.
from this list.
2
two-
million, 2
4, 5, 7, and 9. Out of 9, 5.
these 9 petitioners are there in this writ petition.
9.
So according to you, these 5 persons
Opted.
applied within the time.
Right.
Show me that document.
That page 6 first.
Page 6, yes.
Gopal Chandra. 2. February 18.
Page 6 is Subhash Chandra Jha.
No.
No,
Oh, sorry.
page 6. Gopal Chandra Mondo, signatory at the bottom.
Yes.
But he applied on 23rd February 2018. That application is there, annexure.
When did he retire?
He retired on 31st of December 2019.
Mr. Bhattaji, show me that pension regulation, that clause of 6 months.
That is in the statute.
It is quoted in the result order also, page 79.
That is statute. Yeah.
Statute you have annexed.
Yes, yes.
Regulation you have annexed.
Statute annex করা আছে?
Yes, yes, page 14.
Page 14, yes. Yes, sir. Kindly come to the internal page 502.
502.
Yes. Here is a 502 internal page of the gazette.
Oh,
Page
yes,
running
stop.
page 10, yes.
Yes, yes, I've got that page.
Page 23.
502, yes.
Page 23.
Application for grant of pension.
Well, kindly come to clause number 59. That is chapter 10, application for grant of pension, third clause, formal application. Every employee shall submit a formal application for pension in prescribed form at least 6 months in advance of the date of his anticipated retirement.
Previously, there was no pension scheme. Prior to this.
Those are contributory provident fund scheme.
Only CPF scheme was there,
Yes, there was no pension scheme.
no pension scheme,
So the pension scheme was introduced for the first time in 2001.
my lord.
Now, with effect from that introduction, all the employees were covered under these pension regulations.
My lord. Subject to option. According to them.
On and from the date when it came to others subsequently appointed, no.
Subsequently appointed, it's not
Yes, subsequent appointees must get it. Automatic.
Yes,
Subsequent
yes,
appointments
subsequent
automatically
appointment.
became under the pension regulation. And my lord, those who were already in employment of
Madam, kindly come to 2 subsection 4.
Yes.
Shall be binding on all new entrants. That is what I am saying. Subsequently appointed, all are bound by this.
My lord.
So pension will be extended. There is no question of any option to be exercised. Option to be exercised comes the question for the
In service person.
yes in-service persons who were in service as on the date of introduction of this scheme.
My lord.
They have to opt for pension prior to 6 months. So there was a time limit for this, no.
Within 6 months from the date of publication in the official gazette.
This was also there.
Yes.
Where is
Your
that?
Lordship, kindly consider page 79. I do not have the supplementary affidavit. Kindly see the recent order, page 79.
Yes.
Now, third line, regulation 6 of the said pension regulation is as follows. The
Yes.
employee who may prefer to come under the purview of these regulations shall have to exercise his option within 6 months from the date of actual publication of these regulations in the
79
official gazette. Therefore, as soon as, my lord, it published in the official gazette, one has to exercise it within 6 months.
This
from
is regulation
thereafter.
6.
Yes. Now,
Give me a minute. Give me a minute.
होते नहीं এটা কি কারে भी
recent order.
reason order.
Yes. So subclause 3.
Yes, yes. Shall be treated as if he had not opted towards the pension rate. Absolutely. Subclause 3. Now, my lord, it was published in the official gazette. What my learned senior friend's contention was that it was not.
Subsequently, the time limit was also extended in 2006.
Yes. Now, that your lordship will find page 79, third paragraph from the end. It is also a matter of record that another circular was issued on 24th of July 2006 by the company, extending the date by which the option should be exercised by.
Mr. Bhattaji, you are relying upon rule 59 or regulation 59 only.
Yes, yes. That is a
Nothing more
statute.
than that.
That is a statutory provision, my lord. in the published in the Gazette. That is a statutory provision, and that these are administrative orders probably regulating it.
No,
This is a Calcutta Tramway Company Limited Employees Regulation 2001.
Yes, this, this regulation you are relying on regulation 59.
My lord.
So what is the submission with regard to regulation 6?
Regulation 6, my lord,
Regulation 59, Mr. Bhattacharya, subject to correction, gives a different meaning altogether.
Regulation 59.
Has to be read along with regulation 6.
But in 2001, my lord, the regulation 59, 59 was covering the field.
6
Because
was also covering the field.
regulation
6 was also covering the field.
my lord, the pension scheme was introduced in CTC. Well, I am reading from the impugned order, page 78.
Page 78, yes.
Third paragraph, last paragraph. It appears from
Yes, yes,
record
yes, I've got
that
that.
a pension scheme was introduced by
Calcutta
CTC
Tramways, CTC.
Tram Company.
Now Transport Corporation.
Yes.
Yes.
For its employees known as Calcutta Tramway 1978 Employees Pension Regulation 2001. This is the introduction. The pension regulation came into force with retrospective effect from 1st April 1997. Therefore, this regulation is effective from 1997. The pension regulation was notified in Calcutta Gazette on December 21. Under Regulation 2/3, pension regulation were made optional for employees who were of the payroll of 1978. When the pension regulation were notified in the official Gazette, they were also made optional for those who had retired prior to 1997. When the
You are not
regulation
on that. You did not retire prior to.
No,
now
no,
you
no, no.
retired prior to 1/4/97.
no. When the regulation came into force. However, under Regulation 2/4, the pension regulation were made binding on new entrants into service. Very good.
You are not on.
No,
also on that.
I am not. The pension regulation were made applicable to all categories of employees except those mentioned in Regulation 3. Under Regulation 6(1), the employees were required to exercise the option whether the under Regulation 3, under Regulation 6(1), an employee is to required to exercise option whether desired to fall under within the ambit of the regulation within 6 months from the date of publication of the regulation in the official Gazette. But he is also referring to the same regulation, Regulation 6,
Yes.
2001 regulation.
Yes, yes.
Now, kindly, my lord, 2001 employee who 2001 regulation 6 may I place for your lordship. The employee who may prefer to come under the purview of these regulations shall have to exercise his option within 6 months from the date of actual publication of the regulation in the official Gazette.
You have not done that.
I have not done that.
Yes.
Now, pension chapter deals where this particular issue has been further dealt with. The authority has made a separate avenue for those who are already in employment by giving 6 months time prior to retirement to apply.
Two is very relevant. What you are submitting here, sub-regulation 2 comes. Place that. No, the page 79.
Yes,
The next paragraph,
Yes, my lord.
the paragraph which you are placing, the next paragraph.
Ah.
What you are submitting, the
Yes,
question refund.
yes.
Yes.
Regulation 6 of the pension regulation as follows.
No, next keep one, come to 2.
The employee who were on payroll of the company on the date on
You
which,
are on that?
yes, I am on payroll.
Yes. Next proceed.
On the date on which the regulation came into effect and onwards, but retired on subsequent date, but before the publication of the regulation may exercise their option within 6 months from the date of publication of their these regulation, provided they refund to the
Yes.
company
So
the
these
full.
are, that was the case which I told you.
Hmm.
If this comes after, for the benefit of the retired persons,
Yes.
they will have to refund
Hmm.
what you are submitting at the beginning.
Yes.
I am ready to refund together with interest. Regulation provides that for the retired employees.
Because it has a retrospective effect.
Yes, only for those.
But
All these
retired on
schemes are more
subsequent
or less similar, Mr. Bhattacharjee, in all the institutions, similar schemes.
employees who are on payroll of the company on the date on which this regulation came, that is in 2001.
Yes.
Someone is
Not
in
on
payroll
97, it came on 2001.
of 1997
97.
effect.
So they could not exercise at that point of time. They can
But retired
exercise now
subsequent date, but
within
before
6 months.
before publication of the
Yes.
notice, may exercise their
So
option.
it came
So and
into
so
effect on 97, but notice it was published in 2001. For those, they can also exercise.
No, they can also exercise.
Yes.
But I understand that for your lordship, this is an interpretation of regulation 6. But regulation 59 is not that way interpreted. What is the effect of regulation
It has to
59?
be read as a whole. If you read 59 in such a way, or can you read regulation 59 in such a way so as to make regulation 6 ocious?
But if anyone not
This will
retired
become
after
ocious,
1st
Mr.
of the-
Bhattacharjee. If that is accepted
Yes, ma'am.
prior to the retirement, then regulation 6(1) becomes ocious.
But that is two class of employees have been dealt with. One is 1997 retirement persons are covered by 6(1).
6(1) all. 6(2) is for that.
But 6(1) has been further interpreted.
6(1) is for all who were on service as on the date of notification.
That's true. We are all
For all.
covered. We are all covered, but we have to.
So, Mr. Bhattacharjee, if you read 59 in such a way to make regulation 6 ocious, if your argument is accepted, yes, I need not apply under 6(1) within the time limit. At the time of retirement, I am retiring into 2024 December. On 2024 June, I can make,
application.
I can opt for.
Yes.
If that is accepted, 6(1) would be rendered ocious.
But 6(1) is only to
Anything
those.
more, Mr. Bhattacharjee?
6(1), my lord, is otherwise not affecting those class of persons, my lord, who did not opt. But this opportunity, what is the effect of this opportunity given? My lord, kindly, my lord, once again, my lord, I read the regulation statutory provision
Yes.
where it is specifically stated
Regulation 59.
59.
Yes.
Regulation 59, prior to a date of retirement, my lord, I am to exercise option.
Yes, that is clear. I accept your submission with regard to that.
An application is to be made. An application for pension is to be made. Every employee shall submit a
Yes, I follow
formal.
your submission, Mr. Bhattacharjee. Regulation 59 gives you a right to apply for pension within
Prior
6
to
months.
6 months, prior to my retirement.
I follow your argument.
And so far as regulation 6 is concerned, my lord, apparently it appears to be, my lord, there are two contradictory stand in the statute. But apparently
Then
it appears.
what should the court do?
Benefit for the petition.
What should the court
Now,
do?
this is a benevolent, my lord, scheme. The person who has applied
What is
under
the rules of, what are the rules of interpretation, Mr. Bhattacharjee? What are the settled position of law? If there are two apparent conflicting provisions in a statute or in a regulation,
if it
how
is,
they have to be read? Will the court read, or shall it be interpreted in such a way to give effect to one, the other regulation will become ocious,
everything,
or to harmonize those?
my lordship definitely will harmonize, keeping in mind the plight of those 5 persons who are before your lordship. These are all, my lord, skate over. This is nothing to give any avenue to someone to opt today. There is no possibility of having further introduction of the
You have
beneficiary.
the decision of the Honorable Supreme Court in the matter of Board of Trustees for the Port of Calcutta versus Captain Onadi Das.
We are
Have you got that judgment?
I have not brought that judgment.
না, না, ওটা দরকার নেই, এটা আমরা দেব, এই জাজমেন্টটা
I appeared in the single bench before the division bench. I succeeded.
Supreme Court also upheld your lordship.
No, that is why I stopped there. That is why I said Board of
Trustees. Malad, এই
did
judge-
not, but only one thing, relief was granted in such a manner, since for that petitioner, they have not touched that, but as a law, they have declared it should not be done. So those were also retired. Mr. Bhattacharya, those were retired. The scheme, I tell you, those persons retired. The scheme was brought in after retirement of those persons for the benefit of retired persons. There was no wide publication of those schemes. Much better case than yours. No publication of the scheme introduction, and think the employees were under the CPF scheme, they retired. Thereafter, this scheme was introduced, no wide publication, but for the benefit of the retired employees.
their option
Also-
was not allowed.
In one case, my lord, I appeared for some of the employees of West Bengal State Electricity Board. They also
কত
introduced
paragraph?
a scheme under the Electricity Act, my lord. This has to be, my lord, published in the official gazette, which they did not. We challenge this, challenging that this is a procedural by this, therefore, this should go. Now, Honorable Division Bench, my lord, presided over my lord Justice Sanjeev Banerjee, my lord, as his lordship then was, my lord, said that your conduct will
59,
prevail over this
64 হবে।
procedural impropriety, because you slept over your right for 20 years.
দুজনকে বেনিফিট দিতে হবে
Yes, Mr. Bhattacharya.
Malad, one judgment I am relying on.
আগে 6 এর আর 59 টা ডিস্টিংগুইশ করুন
দে judgment দেখা।
11 প্যারা 11
For what proposition?
প্যারাগ্রাফ 11
Paragraph 11 I am relying on.
Mr. Bhattacharya, for what proposition?
রিফান্ড অফ দি
So far as the question of refund of the fund, paragraph 10 and 11.
10 and 11, yes.
এটা অ্যাপ্লাই করে এটা ইস্যু নয়।
আমি রিফান্ড করে দিব এনিটাইম রিফান্ড দিলে আমি যদি স্টেটে লস না করে তাহলে প্রবলেম লস না করে
তা তো বুঝলাম, ওটা তো কথা হলো, সেই জন্য তো ইন্টারেস্ট দিয়ে ফেরত দিতে বলেছিল।
যেখানে 6 থাকবে 59 থাকবে তাহলে
Yes.
প্রফিট পাবো না
Yes.
Now, so far as regulation 6 and 59 is concerned, plus 6 for all, including those who are retrospectively retired.
Paragraph 7 is the distinguishing factor. Paragraph 7 of the judgment. He submitted his option in
I've
time.
seen that. Paragraph 10, I've seen that. Yes, next.
That's why I did not press hard.
Yes. Any
The
other judgment?
admitted position, 5 persons are before your lordship. Admitted position, they are agreeable to refund the amount. Admitted position, regulation 6, if it's read by a
Mr. Bhattacharya, have you calculated the amount together with interest? What will be the amount they will have to refund?
yes, yes.
Calculated. What is the figure?
The
according to you-
amount of that also you have given. কত টাকা করে
না 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 আর ওরাও তো ফেরত দেবে
No, that has been directed to be adjusted. In this judgment, the Supreme Court has said that whatever amount is required to be refunded, that should be adjusted.
Where is the scheme, Mr. Bhattacharya?
No,
Supreme Court can say under 142.
no, question of Malad.
Show me the scheme which provides for adjustment. There is a scheme in port trust. Initially to refund, modified for adjustment.
That also not allowed by this court, Malad, directing that refund.
But there was a scheme. Initially, those were the arguments that initial I could not, subsequent that was further liberalized for adjustment, much more beneficial. I'm opting for that.
Yes.
I took these points when I was on that side in those matters.
So so far as that monetary part is concerned, Malad, I am not
What
on
will be
that.
the amount? Have you asked your client or have you the instructions? What will be the amount? You have not asked your client.
5 persons, Malad, they agree to refund it. They have
Yes,
money.
yes, madam. What do you say? Can you not allow them?
My lord, I cannot allow them.
Why?
My lord, firstly, because this issue,
Why are you starting with madam? No, I cannot allow.
because my lord, I am bound by the decisions of this honorable court, and my lord, this honorable court has already decided this issue in a division bench judgment, my lord.
In respect of this,
Yes.
in respect of this
Yes,
CTC,
yes.
where is that?
My lord, it is. My lord, it has been annexed with my affidavit in opposition, my lord.
Annexed to your
Yes, yes.
opposition.
My lord, this issue had also came up for consideration before your lordship, my lord. Your lordship has also dealt with this issue, my lord, in an identity.
Division bench was presided over by Justice Mhatre.
Justice Mhatre. And my lord, your lordship had considered
Yes,
that division bench order, my lord, and considering that the other set of writ petitioners who were before your lordship, my lord, you.
Mr. Amjad Ali appeared in
Yes,
that.
yes, my lord. Now, my lord, my lord, I should inform this honorable court, my lord, that judgment has been taken up in appeal, my lord. Presently, it is pending before the honorable division bench, and my lord, these writ petitioners have come before this honorable court, my lord, seeking for the same benefits which has already been settled by the division bench, stating that it cannot be allowed because they have not exercised their
Where
option.
is that order?
My lord, it is appearing at page number. My lord, it is with annexed in my affidavit in opposition, my lord, and it is appearing in page number 23.
23.
Yes, of my affidavit.
You are 3, 4, and 5.
My lord, I am appearing for CTC WBTs, my lord.
But there is no division bench judgment here.
My lord, in my affidavit in opposition.
Yes. আর কোনো এফিডেভিট অপোজিশন আছে?
Well, I have exercised only one affidavit.
Order, madam.
Yes, yes.
Page 23.
Page 23, my lord.
23.
My lord,
I do not have any 23 in the opposition. আছে?
my lord, it has been
Yes.
affirmed on 20th February 2024, my lord, this affidavit.
Single bench.
Appearing on behalf of, my lord, respondent number.
So was this point of regulation 59 taken here?
My lord, regulation 59 was
No,
not.
no, was this taken
No,
here?
No,
So-
regulation 59 was not taken here, my lord, with respect to regulation 59, my lord, as has already.
What is your submission with regard to regulation 59?
Yes, my lord, as has already fallen from your lordship, my lord, regulation 59 has.
Don't rely upon the observations
No,
of the court. Make your
My
own
lord-
submissions.
My lord, the regulation 59 has to be read with regulation 6. My lord, regulation 59 itself clarifies that the regulation 6, one has to exercise their option first under regulation 6.
Where is that?
My lord, I shall take my lord to the regulations, my lord. The regulation. My lord, my lord, regulation 59 is a part of chapter 10. My lord, I'm reading from
Part of chapter
10 of the.
yes.
Yes. Now, my lord, before regulation 59, my lord, may I read regulation 57 first?
Regulation
57.
57, yes.
Application of these regulations. For the regulations in this chapter, apply to all employees applying in pensions under these regulations. Now, my lord, first, in order to apply under these regulations, one has to come within the purview of these regulations. Now, my lord, one will only come within the purview of this regulation only after exercising the option in case of the existing employees who are there in existence in employment, who were there in existence in the employment of WPTC, my lord, when these regulations came into effect,
Yes.
and the case of the petitioners as such. Now, my lord, the case of the petitioners cannot be considered under these regulation 59. Regulation
Because they did not opt
yes.
under regulation 6.
Yes, regulation 59 does not speak of option. There are two differences, my lord. Applications and
Nothing more.
exercise. No, ma'am. Exercise of options are two different sets. They have not exercised their options. Hence, they
The
cannot
submission
prove
is that since they did not opt at the relevant point of time
yes,
as mandated under regulation 6 or
Yes.
within the extended time thereafter,
yes,
they cannot take the help of regulation 59.
right. Yes.
Anything more?
No, my lord.
Yes, Mr. Rai Mukherjee.
My lord, I adopt, but my learned,
All right. Yes, Mr. Bhattacharya. Anything in reply?
Only thing, my lord, regulation
What
6
is
is
your submission in reply to a submission with regard to
regulation. She is saying that regulation 659 is subject to compliance of regulation 6. That is exactly what is. But regulation 59 does not speak for that. If it is a chapter dealing with the grant of pensions, independent, separate, with application of mind, the chapter has been incorporated in the said regulation. This is a chapter for pension. And pension chapter, application for grant of pension. And application for grant of pension, time limit is fixed, within which you can apply. If I have an independent right to apply under regulation 59, I am entitled to be considered for pension.
regulation 6 cannot come in your way.
The regulation 6 cannot stand on my way in taking
That is
the
your
benefit of.
submission.
Yes, that is my point. Okay.
Ashwin. Mr. Bhattacharya, there are many writ petitioners, not 9. You said only 9.
9 petitioners are eligible, my lord, who applied for.
Tell me
Only-
from this cost title of the writ petition, who according to you will be entitled?
My lord,
Because I was,
my lord, may I make a small submission?
yes.
My lord, this writ petition was, my lord, has been preferred challenging the order of the managing director in case of the writ petitioners who were part of the previous writ petition that has been dealt by my lord only. Now, my lord, this is an order in person, and that submission, my lord, I had already made. Now, my lord, the other writ petitioners and the applicants in the CAN application who have been sought to be added as party, my lord, they cannot apply under this writ petition, and that has been clarified by Justice Mantha. And my lord, Justice Mantha had stated that the CAN applications will not be taken into consideration, and they will not press for it, despite that
only
there is
for-
a separate CAN
But these
application.
parties were added.
No, my lord.
Yes, 6, 7, 8, 9.
My lord, they were not.
10,
They
11.
were added as respondents.
Huh?
My lord, will
Yes.
kindly see they were added as respondents because on it is Justice Banerjee's order. My lord, on the first day only I objected to this, and Justice Banerjee had directed that these persons concerned be added as a respondent, and hence the cause title of the
Mr.
writ petition has
Bhattacharya,
been
6
changed.
to 11. Are you, is it your submission that they are entitled to as per your submission? Or they have applied within 6 months? Respondent number 6 to 11.
No.
They have not applied. So I can refer to the submission that-
I cannot individually tell you lordship, my lord, my junior can say so. কারা কারা apply
No,
করেছে?
Mr.
mark
Bhattacharya,
করেছে?
with the cost title of the
তারা
writ petition,
petitioner
I
কত
find
নম্বর?
there were 15 writ petitioners and there were only 5 respondents. Thereafter, respondent number 6 to 11 were added
Yes.
on 24th of January 2024.
My lord, added as respondents.
Yes, added as respondents on 24th of January 2024.
Yes.
Why they were added?
They were 15 petitioner in this writ petition, lordship. They raised one objection that the first writ petition, these persons 6 to 11 was not in the writ petition. For that reason, we have challenged this order before the authority. Thereafter, these orders, the authorities order challenged before your lordship.
Yes.
For that reason, these 6 persons
Before the authorities, 6 to 15 were parties.
parties in the first writ petition.
Yes,
And-
6 to 15. This respondent number 6 to 11 were not parties.
They raised that objection before the single bench. Prior to that,
My lord, I have the previous writ petition also. I can supply the cause title, my lord.
No, I could not follow your submission. In the previous writ petition, this writ petition number 6 to 15 were the petitioners.
was the petitioner. But
Yes.
they raised one objection that they were not the writ petitioner on that occasion.
Who raised objection?
The authority, the Calcutta Town Company.
Yes.
Then the order was passed by this honorable court that the 6 to 11 to be made added being the respondent. For that reason, the 6 to 11.
Who are representing 6 to 11? Have you served them? Have you served a copy of this writ petition upon them? Are you claiming any relief against them?
No, at that moment I am not claiming it.
Why have you added them?
Added করেছিস কেন?
Ashwin. Yes, Mr. Bhattacharya, only one thing. From this cost title, you tell me for
Who are
whom
the
you are
person?
pressing your claim.
ওই পাঁচজনের নামটা পাপা বলে দে যে কস্টাটলি তাদের নাম আছে কত কত নাম্বার।
Ashwin. Yes,
টেবিলটা থেকে
Agustine,
ধরে ধরে বল।
put it in a piece of paper. For whom you are pressing. I shall record your submission, Mr. Bhattacharya, that you
My
are
lord,
not
I am
pressing
pressing for
in respect of others.
গোপাল চন্দ্র মন্ডল।
Put it in a piece of paper. Give me the names. 15
একটা কাগজ দেন।
persons have joined together and have filed this writ petition challenging the order of the managing director,
পূর্বপ্রসাদ আছে,
Calcutta, Tomways,
অশোক আছে,
TTC,
পান্ডে।
Calcutta Tomways Company within bracket 1978 bracket close limited, which is now known as West Bengal Transport Corporation Limited. Date টা বলেছি, has challenged the order of the managing director dated 13th of July 2023. Paragraph. The petitioners
কত কত নাম?
claim, no, the petitioners are all retired employees. First up, the petitioners claim that petitioners claim that within 6 months, Mr. Bhattacharya, kindly hear this. The petitioners claim that within 6 months prior to their respective dates of superannuation, they have exercised their option to come over to the pension scheme from the contributory provident fund scheme. First up, the petitioners on an earlier occasion approached this court by filing a writ petition being WPA 12697 of 2021, which was disposed of,
They applied, they filed their application.
which was disposed of by an order dated
the retirement.
May 10, 2023, by directing the Managing Director of West Bengal Transport Corporation, for short WBTC, bracket closed, to consider the representations of the petitioners dated December 25, 2020. First up, by the order dated July 13, 2023, the prayer of the petitioner stood rejected. First up, being aggrieved, the petitioners have approached this court. First up, paragraph. Mr. Bhattacharya, learned advocate, appearing for the petitioners, comma, on instructions, comma, submits that only the petitioner numbers blank রেখে দিন,
They proposed to
have exercised their option to come over to the pension scheme within within 6 months prior to their dates of retirement. এটা ওই যে বললাম ব্ল্যাঙ্ক বললাম না, দেখুন পিটিশনার নাম্বার 2, 4, 5, 7 and 14. Mr. Bhattacharjee, in his usual fairness, Mr. Bhattacharjee, in his usual fairness, submits that the other petitioners have not exercised their option.
আমরা সেটা বলছি
ওই within 6 months করেছো কিনা?
খালি এই 9 এর মধ্যে বাকিটা বলছি না, কিন্তু বাকি 6 to 11 আমি কিছু বলছি না।
6 to 11 respondents এর ব্যাপারে we are not saying anything.
Not the respondent, as the
Petitioners দের মধ্যে। আমি তো
petitioners.
বলছি, কেন তুই বলছিস এরকম কথা?
কি বললাম?
বলবি তুই respondents দের হয়ে?
Petitioners, the other petitioners have not exercised their option within the time limit stipulated under regulation 59 of the pension regulation. By drawing the attention of the court to regulation 59 of the
বলছে না তো।
আমি বলছি ওরা পরে গেছে।
আমার petitioner দেরও বলছি তো। ওদের 15 জনের মধ্যে
কনফার্ম করেন সেটা আমি আমাদের ডকুমেন্টস
of
কিন্তু প্রথম
করে ব্র্যাকেটের মধ্যে লিখবেন, the Calcutta Tramways Company within bracket 1978 bracket close limited employees pension regulations 2001 ব্র্যাকেটে লিখবেন for short the 2001 regulations, Mr. Bhattacharjee submits that only 5 petitioners have exercised their option to come over to the pension scheme. First of, he submits that the managing director, while passing the order dated 13th of July 2023, did not consider such fact. Full stop. Mr. Bhattacharjee submits that the aforesaid 5 petitioners are willing to refund the amount which they have received on account of contributory provident fund as well as gratuity, no only contributory provident fund along with interest if this court allows the petitioner to switch over to the pension scheme. ওটা বললাম, together with interest বলেছি, together with interest thereon, as may be directed by this court, because there is no scheme for regulating, as may be directed by this court, together with interest thereon, as may be directed by this court. First paragraph. Mr. Bhattacharjee further, in support of such contention, Mr. Bhattacharjee places reliance upon a decision of the Honorable Supreme Court in the case of Calcutta State Transport Corporation and others versus Ashit Chakraborty and others, reported at 2023 SCC Online SC 594. The paragraph. The learned advocate appearing for the West Bengal Transport Corporation submits that the petitioners did not exercise their option for switching over to the pension regulation within the time limit stipulated under regulation 6 of the 2001 regulation or within the extended time. She further submits that the petitioners have approached this court at a belated stage, and this court should not, therefore, this court should not entertain the claim of the petitioner. She also placed reliance upon a decision of the Honorable Division Bench in the case of in APO 302 of 2015, in the case of Dilip Shankar Das and others versus State of West Bengal and others, just reliance upon a judgment dated 22nd February 2016 in APO number such and such in support of such contention. Mr. Rai Mukherjee, learned advocate, appears for the state. He, however, adopts the argument advanced by the learned advocate appearing for the West Bengal Transport Corporation. Heard the learned advocates for the parties and peruse the materials placed. Paragraph. Regulation 2 of 2000, Regulation 2 within bracket 1 of the 2001 regulation states that the pension regulations shall come into force with retrospective effect from 1st of April 1997. Subregulation 3 of Regulation 2 states that the pension regulation shall be optional to the employees as in Regulation 2 within bracket 2 above. The said regulation was notified in the Kolkata Gazette on December 24, on December 24, 2001. Regulation 6 within bracket 1 of the said regulation states that the employee who may prefer to come under the purview of these regulations shall have to exercise his option within 6 months from the date of actual publication of these regulations in the official gazette. Regulation 6.3 states that failure to exercise option by an employee within the stipulated period as referred to in Regulation 6.1 and 6 within bracket 1 and within bracket 2 shall be treated as if he had not opted towards the pension regulation. First up, the managing director in the order dated July 13, 2023 noted that the petitioners did not exercise their option in terms of the pension regulation, though there was sufficient time given to exercise the same. First up, it was further recorded therein that another circular was issued on 24th of July 2006 by the company, extending the date by which the option should be exercised by existing employees for the death cum retirement benefit scheme of 2001. And all such employees who opted to fall within the ambit of the scheme were required to exercise their option by July 31, 2006. The managing director further recorded factual finding that at that point of time also, the petitioners did not exercise their option under the pretext that they were under the impression that the pension regulations covered them and it was not necessary for them to exercise any option. Mr. Bhattacharjee, learned advocate appearing for the petitioner, however, does not dispute the said factual finding. According to Mr. Bhattacharjee, Regulation 59 of the 2001 regulation gives the employees an additional right to exercise their option within the time limit stipulated therein. He submits that the petitioners have submitted their application within the time limit contemplated under Regulation 59 insofar as the aforesaid 5 writ petitioners are concerned. Paragraph. The question that arises for consideration is whether a person who has not opted for pension, who have not exercised, opted now, who has not exercised for, who has not exercised their option to switch over to the pension scheme within the time limit stipulated under Regulation 6(1) or within the extended time by circular dated, the circular issued in the year 2006 can be allowed to switch over to the pension regulation by filing an application within the time limit stipulated under Regulation 59. First up. Regulation 2, Regulation 6 within bracket 3, no, Regulation 6 within bracket 1 specifies the time within which an employee shall have to exercise his option and such time shall start running from the date of actual publication of the regulations in the official gazette. It is not in dispute that the regulation was published in the official gazette on December 24, 2001. Subregulation 3 of Regulation 6 provides that failure to exercise such option shall be treated as if the employee had not opted towards the pension regulations. First up, it is not in dispute that the petitioners, admittedly, the time to exercise such option was extended by a circular issued on 24th of July 2006. Paragraph. It is not in dispute that the petitioners did not exercise their option within the time limit stipulated under Regulation 6 within bracket 1 or within the extended time as per the circular dated July 24, 2006. First up. Regulation 59 falls within Chapter 10, Roman 10, X. Chapter 10 deals with application for grant of pension. Regulation 57 within bracket 1 states that the regulations in this chapter, bold kore deben, apply to all employees applying for pension under these regulations. First up, Regulation 59 states that every employee shall submit a formal application for pension in prescribed form within bracket annexure at least 6 months in advance of the date of his anticipated retirement. Full stop. Regulation 59 deals with the procedure for applying for pension. Full stop. In order to be eligible to apply for pension, an employee ought to have come over to the pension scheme by exercising their option within the time limit stipulated under Regulation 6 within bracket 1 or within the extended time as stipulated in the circular dated 24th of July 2006. Admittedly, it is not in dispute that the petitioners did not exercise their option to switch over to the pension scheme within the aforesaid time limit. So that apart, the petitioner immediately after retirement, the petitioners were paid the benefits of gratuity as well as the amount on account of contributory provident fund. The petitioners received the same without any protest. Full stop. Mr. Bhattacharjee would contend that the petitioners, that the amounts were transferred directly to the bank account of the petitioners. Full stop. However, it is not the case of the petitioners that they were not aware that the funds on account of the aforesaid accounts have been transferred to their bank accounts. Full stop. The reasons for which the petitioners did not take any steps for either refunding the amount to the company or to approach the court immediately thereafter is best known to the petitioners. Full stop. The claim of the petitioners that they have applied for pension in terms of Regulation 59 cannot come to the aid of the petitioner, as the petitioners have neither exercised their option within the time limit stipulated under Regulation 6 within bracket 1 or within the extended time limit as per the circular dated 24th of July 2006. This court is therefore not inclined to accept the submission of Mr. Mr. Bhattacharjee would vehemently contend that there is an apparent conflict in the provisions laid down in Regulation 6 within bracket 1 as well as Regulation 59 insofar as the time limit for exercise of option to come over to the pension scheme is concerned. In view of the observation, this court, in view of the observations made herein before, this court is of the view that there is no apparent conflict in the aforesaid provision because Regulation 6(1) deals with exercise of option and Regulation 59 states the manner in which the person who has already come over to the pension scheme shall apply for pension. Good stuff. It is also well settled that in case of any apparent conflict of two statutory provisions, it is the duty of the court to harmonize the same so as to give effect to both and not to make one of the provisions ocious. If the contention of Mr. Bhattacharjee is to be accepted, the provisions laid down under Regulation 6 shall become ocious. Full stop. In Asit Chakraborty Supra, the respondent employees had submitted their option way back in the year, had submitted their option immediately after the regulations were notified. Such is not the case in the case on hand, as observed herein before. First of the said decision being distinguishable on facts cannot come to the aid of the petitioner. For all the reasons as aforesaid, the writ petition stands dismissed. There shall be, however, no order as to cost adjourning photo stat certified.
তুই বল রেকর্ড তুই বল
Yes,
Lordship, please to record one line that we are taking the submission that the others have not applied before the authority within 6 months their option. I am only submitting before your Lordship, please record that as per the records of the documents.
আচ্ছা ছেড়ে দিন, কেটে দিন, ওখানটা একটু লিখে দিন। Nothing has been produced before this court to show that the other petitioners have applied for pension within 6 months prior to their respective dates of superannuation. ওইটা this usual fairness submits কেটে দিয়ে ওই জায়গাটাতে হ্যাঁ, prior to their respective dates of superannuation. Sorry, Mr. Bhatt.
as well.
Yes. All these.
Item number 6.
Yes.
My lord, I am for the petitioner. My lord, I have concluded my argument that transfer from Alipur to Jalpaiguri. My lord, that matter, Mr. Samuto is yet to.
Can you give me some dates? When you left the matrimonial home,
My lord,
or do you have a copy of your plane?
yes, I do have.
Give me a copy of your plane. You can give me some important dates when you left your matrimonial home.
My lord, I have left 2000.
Give me the exact date.
My lord. June 1, 2021.
June 1,
2021.
2021.
Yes,
Left the matrimonial home.
yes. For the last. Forever.
Yes. Now, what is the first proceeding which you initiated?
Man, the
The
first
criminal proceeding or the matrimonial suit?
490.
First is 498A. When?
13th July 2021.
13th July
2021.
2021.
Pilot.
498A
And
at Alipur.
at Alipur. Along with 3/4 DP.
Next, 125.
Next is Milord 36.
Next is
36.
36 of domestic
Special
violence.
Special marriage.
36 of Special Marriage Act.
My lord. 27. Read with 36.
When?
In 2022.
What is the date?
No, opposition.
Page number 8-9. 8-9. 11.
No, Milord, I am stand corrected, Milord. It has been filed on 27th of October 2021.
27th of October
2021.
is
2021.
matrimonial suit.
My lord, section 27.
Yes. Next. What is the next proceeding?
No, 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 no.
এই তো।
না না 125 এটা হচ্ছে 125 এর মামলাটা মানে দিস পেজ 8 is the 125 proceeding
Page 8 of my opposition. my
of his opposition.
Page. So
Page
125 is on what date?
27th October
That is
2025.
125.
125.
Yes.
Thereafter DV
That is
proceeding.
also at Alipur.
Alipur.
Every proceeding is before Alipur.
Yes.
DV,
Next.
DV proceeding is on 6th September 2022.
6 September 2022 is
DV.
domestic
DV.
violence proceeding.
Yes.
Page 9 I have annexed.
And matrimonial suit on 11th November 2021. Prior to that.
11th November 2021.
Yes.
So matrimonial suit is the third proceeding.
Matrimonial suit.
Is the third proceeding.
Yes. Yes. Yes.
11 or
This is a. Do you have a copy of your plane?
Yes.
all the
And what
case-
is the age of your child?
Well, 9 years now.
9 years.
Right now, 9 years.
all the case status I have annexed with my opposition.
What is he doing now?
Studying, man.
Which class?
Malar 9, it will be class 3.
Class 3.
Class 3. At Jalpaiguri.
That you have stated in the petition.
Yes, my lord.
Which
That is
paragraph?
that paragraph
This was dismissed for default.
These are restored. They are restored.
once. My lord, restoration application has been filed. That is pending.
That is pending.
Pending before your lordship.
Restoration allowed. Restoration allowed.
My lord, paragraph 14, page 7 of my application.
Page.
Page 7, paragraph 14. Bottom portion, it would be.
Yes, at that point of time, 8 years.
At the, my lord, while I have filed this application. Now it's 9.
Now it's 9 years.
9 years.
And who are you staying with?
My lord, with my mother.
Only mother and child.
Yes. Paragraph 12.
Yeah, as per the order of the court, I am paying a lot. All payment has been up to date.
Yes. Yes, Mr. Samanto, why are you objecting to this transfer?
Lot. Only difficulty is I am 60% disabled. The only difficulty I am facing. I have annexed the certificate with my opposition.
What is the nature of disability? Where is
50%.
that?
50%.
So he cannot
Well, that has not been mentioned.
walk properly.
Well, clause 2 says it's by disease.
Substantiate that from paragraph page 7 certificate.
Page 7.
Yes, that is the disability certificate.
Yes, yes.
What is the nature of disability? Substantiate that from that certificate. Government hospital.
Government hospital.
Yes. District hospital, Jalpaiguri. Is the nature of disability certificate that is being issued by government hospital.
That is
So,
also,
Samanto, are you yourself satisfied with this certificate? I'm asking you as an officer of the court.
On examination such as such. Physically. Milord, from top, Milord, the disability certificate,
Yes.
point number 1.
I'm asking you
For
what for? Yes, point number 1. Substantiate that from that.
He
What
is
is the nature of disability?
He is physically
Next.
challenged person. Milord, all these staff, by and staff will go. He is physically challenged person with disability, responded to any sort of treatment. Percentage of permanent variation is calculated at 50%.
Certificate should be more clear.
So Lord,
As
you ask
vague-
for, if your Lordship ask for any further certificate, Lord, I can ask for, but what I have been supplied with, I have produced before Lordship, Lord.
Yes. Apart from that,
Apart from that, nothing, my lord. All the proceedings are in Alipur. I have handed over a judgment to your lordship, my lord, where it has been specifically said that the criminal case will be, where the criminal case will be there, all the proceedings.
what is that judgment? What is the reference?
The copy is with your lordship.
2004,
Yes,
volume 13, SCC
2004,
460.
volume 13.
যা তোমার তোমার
Yes. Small judgment with 5 paragraphs with regard to the grounds transfer
Yes.
file. There's no source already initiated.
And what is the stage of this suit, matrimonial
Evidence
suit?
to be added. Evidence to be added.
Chief filed.
Chief file. Chief file.
that is
File.
My instruction is chief file.
What is the date fixed for cross-examination?
That I don't know. Lord. I have to take instruction.
time.
Yes, anything?
No, but what I was beseeching you, kindly see the cause title of that judgment, what he has cited.
Cost title, why?
Yeah. But
What is there in the
this
cost
has
title?
been filed by the wife herself.
Oh. Yes,
So,
yes.
so this is a norm that wife asks for and usually gets it. I am not saying that this has
So according to you, the convenience of the wife is
Fine.
to be
and
considered.
on that score, my lord, I have
formula that it will be.
my lord, yes, I have never submitted so. And my lord, on that score, my lord, I have submitted another judgment before your lordship, 2005, volume 12, SCC 237.
Yes.
Rajani Kishore Pardeshi.
What does it say?
My lord, wife's interest is paramount.
Wife's
My lord, interest is paramount.
convenience.
Convenience. And one another thing is that this disability certificate shows that this has been issued from Jalpaiguri itself. He is from Alipur.
It can be challenging other proceeding.
No, I'm
So according to you, you could go to Jalpaiguri.
for at least
And
obtaining
the
certificate.
records of this court shows you can come to Calcutta. Records of this case.
Yes, man.
You have affirmed.
Both sides.
You
Well,
have
both sides.
also filed a reply also.
Yes,
You have filed the petition. You have affirmed the affidavit in reply. So either way,
Only rest
it
to
cuts,
either way.
it cuts both ways.
Yes, man. Yes, that's true. That's all.
This is an application under section 24 of the Code of Civil Procedure. At the instance of this application under section 24 of the Code of Civil Procedure is at the instance of the wife praying for transfer of the matrimonial suit number 3216 of 2021. 3216. So many suits filed matrimonial.
But I was also amazed to see this number. But I have checked it up.
Correct.
Correct.
But I have annexed the case status, my lord. It shows 3216. E-code shows 3216.
3216 of 2021. Pending before the
July মাসে এটা।
presently pending could be presently called the pending only. Pending before the learned additional district judge, third court at Alipur. The marriage between the parties took place on September 22, 2012. Full stop. Thereafter, the petitioner and the opposite party started living together as husband and wife, and a female child was born out of the wedlock on October 17, 2016. Full stop. The petitioner left her matrimonial home on June 1, 2021.
21.
Which paragraph you have stated that?
My lord, that is in the my lord,
Plain.
plaint.
On June 1, 2021. Full stop. Paragraph. The petitioner claims that she is at present residing at Moinaguri, and the distance between Moinaguri and Alipur is about 636 kilometers, and it takes around 13 hours to travel one way to reach Alipur from the residence of the petition, from the present residence of the petition. The petitioner states that the minor daughter of the petitioner is at present aged about 9 years. Full stop. Paragraph. The learned advocate appearing for the petitioner submits that since the petitioner submits that it is difficult for the petitioner to travel from Moinaguri to Alipur to proceed with the matrimonial suit. That apart, it is also difficult for the petitioner to come to Kolkata, leaving her minor daughter alone in the house. The learned advocate appearing for the petitioner places reliance upon a decision of the Honorable Supreme Court in the case of Rajani Kishore Pardesi versus Kishore Babulal Pardesi, reported at 2005 12 SCC 237, in support of his contention that the convenience of the wife is to be preferred over the convenience of the husband while deciding an application under section 24, while deciding an application for transfer of a suit / proceeding. Paragraph. Per contra, Mr. Samanto, learned advocate for the opposite party, submits that the petitioner submits that apart from the matrimonial suit, the petitioner has instituted several criminal proceedings under the provisions of the under section 498A of the Indian Penal Code, section 125 of the Criminal Procedure Code, and section 6 of the Domestic Violence,
Domestic Violence Act would
and
be
under the
12.
provisions of the
12.
Domestic Violence Act. He therefore submits that since all the other proceedings, কি বললাম, the wife, না তার আগের সেন্টেন্সে যেটা বললাম, several, and the same are also pending before the Alipur court. He thus submits that since all other proceedings are pending before the Alipur court, the instant application for transfer is liable to be rejected in view of the law laid down by the Honorable Supreme Court in the case of Shoma Chaudhary versus Gaurav Chaudhary, reported at 2004 13 SCC 462. Mr. Samanto places reliance on the disability certificate issued by the authorities of the District Hospital Jalpaiguri in support of his claim that the opposite party is a person suffering from 50% permanent disability, and therefore it is not possible for the petitioner to travel to Jalpaiguri for contesting the matrimonial suit in the event this court decides to, no, in the event, full stop. Full stop, as prayed for by the petitioner in the application for transfer. Full stop. Heard the learned advocates for the parties and peruse the materials placed. There is no quarrel to the proposition of law that while deciding an application for transfer of suit or proceeding, the convenience of the wife is to be preferred over the convenience of the husband. However, after hearing the learned advocates for the respective parties and after going through the materials placed on record, this court is inclined to take a slightly different view in view of the special facts and circumstances of this case. Full stop.
1912 for evidence. 19 December for evidence.
For evidence.
One.
Cross-examination of PW1,
Prosecution
19th December
19 December. 19
2024.
2024.
The petitioner claims to have left the matrimonial home on June 1,
But,
in the month of June 2021. Immediately thereafter, the petitioner filed an application under, in the affidavit in opposition, you have given the particulars.
yes. Mal,
Where is that? Which page?
one thing will not past June cannot be because in the civil division application page 5 para 8 she had stated that she returned to Kolkata on July 10, 2021. Then it will be after the July 10, 2021. Kindly see page 5 para 8 of the revision.
Where have you stated that you have left the matrimonial home?
But paragraph 12 of the plaint.
No, that is
Paragraph
not-
12 of the plate.
But he is pointing this fact from a revisional application, from the transfer application.
is Malad.
There
Paragraph
is a dichotomy.
Paragraph 10.
no para 23 page 6 of the plaint Malad, kindly see
Paragraph
23
Sorry.
23 page 6. Immediately petitioner could leave
yes, Zone 1, the petitioner informed that she would
inform she would leave. Inform she would leave. Could not leave on June 1.
somehow the petitioner is managed to escape from the matrimonial on or about June 1. Last sentence of paragraph
Well,
23.
then Malad, on 24 the petitioner had mother returned to Kolkata on July 10, 2021.
No, maybe return to,
Returned to Kolkata.
that is to collect her belongings.
That will not.
Uh,
My duty is to point out
All right.
whether will take note of that, Milord, your loss. Milord, my opposition, Milord.
Immediately thereafter, the petitioner filed an application
My opposition, paragraph 4.
under the provisions of section 498A/406 of the Indian Penal Code. What is the number of that proceeding? And filed a proceeding on July 13, 2021, and the same is pending before the Court of the Learned AC James at Alipur.
Kosba PS case number 194 of 2021.
Cospa PS case number 194 of
194 of 2021.
being case number,
ACGR
ACGR দরকার নেই তো।
2620
ACGR ছেড়ে দাও।
ACGR case number 2620 of 2021.
Is the registration number before the
ACJM
ACGR
ACGR case number
2620 of 2021.
of 2021. Thereafter, the petitioner filed an application under section 125 of the Criminal Procedure Code sometimes in the month of October 2021, which was registered as maintenance case number 760 of 2021. 760 of 2021. The said maintenance case is the maintenance case is pending before the learned 6th Judicial Magistrate at Alipur. Thereafter, the petitioner filed the instant matrimonial suit on November 11, 2021 before the learned district judge at Alipur. The matrimonial suit was subsequently transferred to the court of the learned additional district judge, 6th court at Alipur, and the same is at present pending before that court.
Hard.
Even after the filing of the matrimonial suit, the petitioner filed a proceeding.
No, my lord. My lord, no, my lord. My lord, subject to lordship's confirmation. My lord, the dates will be, the sequence would be, first one is under section 498 filed on 13th July 2021. Second one would be this DV Act proceeding.
Second is DV Act
6th September 2021.
21.
Oh, sorry, this will be 2022. My lord, I beg your pardon.
2022. This is the last proceeding.
This is the last proceeding.
Even after filing the matrimonial suit, the petitioner filed a proceeding under the provisions of the Domestic Violence Act, which was registered as Miss Case number 438 of 2022, which is pending before the learned additional district judge at Alipur. Thus, from the aforesaid undisputed fact, it appears that the petitioner wife instituted all the proceedings prior and after the filing of the matrimonial suit before the Alipur court. If the petitioner could file 4 proceedings before the Alipur court, this court is not inclined to accept the contention of the petitioner that it is very difficult for the petitioner to come to Alipur court to proceed with the matrimonial suit, as the petitioner is taking, as it is not in dispute that the petitioner is also pursuing the other proceedings in accordance with law. Full stop. That apart, the suit has proceeded, the matrimonial suit has proceeded to the stage of evidence. First of the learned advocate appearing for the petitioner submits that the examination in chief by way of an affidavit has already been filed, and December 19, 2024 has been fixed for evidence of the has been fixed for evidence of the kichu likhte hobe na. Full stop. Taking note of the aforesaid facts, this court is not inclined to allow the prayer for taking note of the peculiar and special facts of this case, this court is not inclined to allow the prayer for transfer of the matrimonial suit from the court of the learned additional district judge, 6th court at Alipur from to the learned district judge at Jalpaiguri.
Well, third court, my lord. Third court, not sixth. Third edition.
Sorry, 6th না third আগেও বোধহয় একটা 6th বলে এটা third করে দেবেন third ADJ at Alipur. Full taking note of the fact that the date has been fixed for evidence, a request is made to the learned additional district judge, 3rd court at Alipur, to fix consecutive dates for evidence of the wife, and the opposite party shall be obliged to bear the traveling expenses of the petitioner wife on all the occasions when the
My lord, as well as
petitioner-
stay, my lord. As well as stay, because I have to stay here. I don't have any place to stay. My lord, but this is the problem, my lord. On the last occasion, my lord, I was submitting because I'll be carrying my child as well.
as the reasonable expenses for the temporary stay of the petitioner subject to production of documents in support thereof. With the above observations and directions, the writ petition stands, the
My lord, not
civil order stands disposed of.
Will it be in a form of a judgment? Will it be in a form of a judgment?
Judgment, you want that? The form of a judgment করে দিলে কি হবে? আচ্ছা, আরেকটা লাইন একটু করে দিন তো। This court also in Soma Chaudhary Supra, the Honorable Supreme Court, after taking note of the fact that the proceeding under the Criminal Procedure Code is pending before the Alipur court, transferred the matrimonial proceedings to a court at Alipur.
My lord, in that case, my lord, kindly add my submission that.
I have distinguished all the peculiar facts.
No, no, my lord, that is okay. Only kindly record that
So,
part, my lord.
Though the petitioner in Soma Chaudhary, na? Though the petitioner in Soma Chaudhary, no, though the application for transfer in Soma Chaudhary Supra was at the instance of the wife,
Right.
but this court cannot lose sight of the fact that the Honorable Supreme Court took note of a fact that proceedings should be the proceedings between the contesting parties should be at one place. Taking note of the fact that the other proceedings are pending at Alipur and the wife is still pursuing those proceedings at Alipur, this court is not inclined to allow the prayer for transfer. Thank you for pointing out that difference.
Deep.
Yes, call the next. Yes, call the next matter.
Lord, I apologize for not being present at the time of call, my lord. I don't.
What happened? I have not dismissed any matter.
Lord, 52 and 53. Both sides are there, my lord.
Yes. Let me call the other matter. Yes, what is the পরপর ডাকুন কোন পর্যন্ত হলো 55 yes you are for the petitioner who is opposing you, Mr. Dor.
My lord, Mr. Om Narayan Rai, he is opposing. My lord, there is lordship need not see.
For bank disciplinary proceeding.
Yes, my lord, I have a technical point because he is not there. Lordship may not hear me everything today itself, but there are two aspects of the matter. One is, if there is a rule in the bank, then even after retirement, the disciplinary proceedings can
Can
be
continue.
continued, then there is a one set of path. Now, the rule which has been given by my learned friend, it's of 1976, and following that, disciplinary proceedings has been held.
So according to you, rule does not permit
Now,
continuation of
I had a
proceedings.
service of 33 years. Proceedings started 2 months before my retirement. It's a very hapless case of now 72-year-old person. Now, before I wholeheartedly make any submissions with all the judgments, I have to be 100% sure that 76 rule, which copy I have received, is not amended.
Is not amended.
Yeah, I have to be sure. So I tried on internet and everywhere. I have not been able to find 76.
You want to seek the assistance of Mr. Rai in that
Yes,
regard.
because if it is amended, then
I
my
have not filed any opposition.
no, despite there is an order, they have not filed any opposition.
So technically there is no requirement, provided you annex all the
Correct.
papers before the.
All I pray is, Lordship may kindly pass a small order on this point, so that if there is an amendment they would produce, then I will take all other points, including whatever is there in my. If this point is available, then it's only the judgments, and I will be most likely I will be seeking very vociferously.
Talk to Mr. Rai, I think that will solve this problem.
My lord, I never got any opportunity to appear when he appeared. I understand that when he appeared, my learned friend appeared, and he took a point of.
Mr. Rai is a senior advocate, so
Yes,
he has
of
to be
course.
assisted by someone.
No,
Who is assisting
no,
Mr. Rai?
by the time he appeared,
No,
he
now.
was-
Today he is appearing, he has to be assisted by
correct, correct.
someone.
There must have been must be that arrangement has to be made, because it is a very new thing, so he has to arrange, and that will happen.
He usually appears with juniors.
True,
Mr. Dhar,
true,
it cannot be known that he used to appear singly,
Correct, correct, correct.
so he was assisted by juniors.
Must have been there had been. So huh?
Yes, there is also Mr. Ayush Sharma, as I find from the recording in the order. He was assisting Mr.
Would your lordship only then we can give a notice? Would your lordship indicate the point with a one-line order?
What is the rule?
Yes, this is
Is it there anything in 76 rules?
yes. Allahabad Bank.
Yes, I've got that.
Allahabad Bank Officers Employees Discipline and Appeal Regulation 1976.
Oh, I've got
Proceeding.
the conduct in one page. Where is that? Which page?
Lordship wants to know what?
I was at page 10, paragraph 17. I found on
Lordship can-
conduct regulation. Where
Yes,
is that?
that's a this Lordship may
You
kindly.
have a copy of the rule.
Yes, yes, I have a copy. The proceedings has been initiated under this rule, that I can
This rule.
under this rule. Punishment of dismissal has been made under this rule. This rule, there is a clear-cut absence that even after retirement, I can continue.
So, Mr. Dhar, you must have taken this point before the appellate authority.
No, this is the point Mr. Rai took. I have not preferred any appeal.
You have not approached the appellate
Because
authority.
yes, I have not approached because of a reason. I know that would just surprise him. The reason was, this was a case of 2012. I filed the writ petitions. There was an interim protections I was enjoying. Now the learned advocate, it was pending for a long time, and there was the
What
directions.
was the interim protection? Because you were challenging an order of the disciplinary authority. What was the
That not
you were
to-
terminated?
I was
Compulsory retirement.
I was not terminated at that point of time.
Oh.
Because they initiated the disciplinary proceedings and inquiry started after my superannuation. As I said, 33 years is not, and no record was absolutely fine. 2 months before my retirement, saying that for the farmers, there are Kishan credits for the farmers. Lordship, no, there are some crop loans of 50,000. Some targets are given. From the zonal, I was given a target that you have to fulfill of these roles are below 50,000. You have to fulfill a target of 200. Now, I achieved the target within 18 days in 2008. According to them, those loans, those KCC, that's called Kishan Credit Card, basically to help the farmers. Those were granted recklessly. That's the
allegation
that's the
against
allegation. And that
So
was,
that was started, proceeding was initiated.
inquiry
just-
proceedings was initiated after my retirement,
Yes.
but the article charge was issued 2 months.
Months prior to your,
Yes.
when did you approach the court?
I approached the court in, I'm giving just a second.
No,
Yeah.
before or after? Before your superannuation or after your superannuation?
Well, it must be, well, give me 1 second. Inquiry, dismissal order, date ta dekho to, order ta, dismissal order. Just a minute. This writ petition is of 2012.
Yes.
2012 writ petition,
So
and
this is of 2024, the earlier writ petition.
no, I'm saying earlier writ petition, because
Yes.
that's the question.
Yes.
2012 writ petitions, the affirmation date, if I, may I, it was on 7th of August. So I filed a writ petition.
Prior to your superannuation.
No, not prior to, because my superannuation was in June,
In June.
June 2012. And this inquiry started in July.
Yes.
I filed the writ petition in August
Yes.
2012.
What was the interim protection granted?
Not
Because
not,
your dues were not released.
I have not received anything for last 33
So
years.
what was the interim protection which was granted?
not to publish any final order. That was the interim protection.
Yes. Then what
Now
happened thereafter?
we had such an unfortunate, I would say, luck, if I can use.
Dismissed for default.
It was dismissed for default in the COVID period,
COVID
a
period.
pre-COVID period, and the
Pre-COVID
learned advocate.
It was COVID, Mr. Dhar.
Yes,
No
yes,
matter.
true. Now, just pre-COVID, and the learned advocate record who was there, I mean, I don't want to name.
No,
He
but,
left the
let us not
profession.
go into that. So
He left
taking
the
advantage
profession of
that,
this Honorable High Court.
yes, taking advantage of that, they have published the final order.
They published it and served me in 2021.
So this is
So
the,
when this writ petition was taken up, of course, the Honorable Court says now there is a dismissal order. So you have to challenge it in accordance with law.
this is that writ
This is
petition.
that petition. So my first question, I have to satisfy your lordship that after a lapse of now 12 years, apart from the fact of the quantum of the number of years, because of the law as it is, I should not be directed to show the door of the appellate authority. I understand there can be cases, some classical cases could be, but for every classical case gets completely diluted when there are facts are so appealing.
Mr. Dhar, was the point of maintainability kept open?
That was not. The order,
Not
lordship,
raised.
the order
Not raised.
not even raised. 12 June order, kindly have a look at. It was by Justice Anirudh Mukherjee, the order. That was not even taken. And I have that judgment of Honorable Justice Indira Banerjee
Judgments
sitting.
are either way.
Either way, correct. But that's why I
On
referred.
that point, judgments are
Yes,
either
but
way.
that's the reason I said I tried to get hold of our Honorable Court while in Supreme Court, saying long number of years being pending should not otherwise. And the rule also.
Or according to this rule,
Yes,
disciplinary proceedings cannot be continued after retirement.
absolutely.
Which is that rule?
But you may kindly have a look at first.
No, only give me that rule which
No, it
is
doesn't.
silent with regard to
No,
that.
it doesn't say anything about absent.
Yes.
It is absent.
Yes. Unless it is specifically provided in the rules that it can be continued, it cannot be.
Yes. And
So what
the-
is that rule? I
the
want to know that.
there is Lordship wants to see under which provisions I can be punished, and under
Yes,
which
yes.
Lordship, there is a direct answer. There is a provisions under which I can prefer, not I have to be an employee. Lordship may kindly have a look at. I'm giving the
This
appeal.
is may appeal. I've seen
Yes,
that.
kindly 17 appeal.
17 as
17. Now the definition of
employee may.
no, the definition of officer employee is there, and that definition is a 3J.
J.
Yes, someone who is holding the post and who has been appointed. Has been means,
So in the absence of the deeming provision,
yes,
cannot be said to be an employee
exactly.
because those provisions are deeming provisions. You
Yes.
shall be deemed to be in
Yes.
service
Yes.
so that it can be
Yes,
continued.
all other judgments have given a different reasoning, but I find there is a additional reasoning.
Mr. Dhol and his senior counsel for the petitioner submits that the authorities of the Indian Bank, of the authorities of the Allahabad Bank, since merged with Indian Bank.
But their merger happened in 2000,
Alright,
April
since
20.
merged,
Yes,
since
correct. That's
merged
correct.
with,
Now it's
Indian Bank
correct.
could not have continued the disciplinary proceedings under the Allahabad Bank officer employees within bracket discipline and appeal bracket close regulations 1976 as the said regulations do not specifically permit continuation of disciplinary proceedings after the superannuation of the concerned officer / employee. Mr. Dhol and his senior counsel further submits that in the case on hand, though the memorandum of charges was served upon the petitioner immediately prior to the date of superannuation, but the inquiry proceedings commenced after the superannuation of the petitioner. So none appears for the Indian Bank. The learned advocate on record of the petitioner is directed to communicate the next date of hearing to the learned advocate for the respondent bank. List this matter in the next week
Yes,
under the same heading.
because only kindly remember, need not be recorded that
Dia deben.
my entire submission based on my available this copy, but I am not putting my 100% confidence. That's the reason I said that,
Alright,
Mr.
so I've said
just
let him
so
come
that-
and show.
so that tomorrow I'm not taken as if I deliberately, because I tried.
Is there any date of publication of
This is 76.
Yes, 76. How do I specify that? Because there is no date of publication.
No, it
I
says
cannot
that
use the
18
expression unamended because it presupposes amendment.
Correct. Lordship may kindly see that it shall come into force from 18 September 76.
So all will come into force.
True.
That date will be same.
Correct.
Amendments may come into force
Correct.
because these regulations have come into force.
Correct.
Some
What I know that post merger, I have been able to see a document. There is an incorporation post merger. Yes, because now this bank, what's the new name is Allahabad Bank. They have it, but that doesn't help. It is of 2020, but I don't know whether it's after 70 because my case has to be governed.
Now it is Indian Bank.
Sorry, it's Indian Bank.
So Indian Bank
has
a rule.
They have a rule.
That deeming provision.
Exactly. That I have read that. I have seen that.
That was earlier also, prior to the merger.
My lord, that part, yes, before 20. Before 20, correct. Before 20. But that is not a different rule altogether.
Your submission will be
So
that you could not have been governed by the rules of the Indian Bank.
No, first I
After
have to be super honest in a sense that
Yes.
I have to be clear.
All right, I cannot specify it
Need
because
not.
of
All
this-
lordship's memory would be there. That's the only thing. Because once he says we have an amendment,
if I forget, he will remind.
True. I would make my submissions on a different aspect. of
नामटा
the
लिखे नहीं है तो ठीक रेगुलेशन है नामटा लिखे नहीं फेरत दे दी.
matter.
Yes,
Deeply
call the
obliged.
next matter.
11, court number 11 of matter.
56.
My lord, item number 56, I am praying for not this week.
You are
Petitioner.
as prayed for by the learned advocate for the petitioner. Hearing of the matter stands adjourned for this week. Next.
Fifty-seven.
I appear for the petition.
Yes. Yes, Mr. Bandhavata. Who is opposing you?
Mr. Kundu, your lordships engaged him. Then
Mir Kundu.
Mir Kundu. He was there just outside.
Maybe he will become. What is the matter?
Lord, your lordships remember this.
You ask any of your juniors to inform him or phone. Do you have his phone number?
I have got his phone number.
Yes.
But he told me that he had left his brief in his chamber.
Oh, he has not brought the brief
He has
today.
not dropped. That he told me.
Then I'm
Well,
making it.
the only problem remains, my lord, it will then go over to the next year.
What is the matter?
The matter is, my lord, the petitioners was employed as laboratory assistants in a training center industry, you should recollect. And after that, my lord, when the this was in 1990, my lord, it was upgraded. Then after the upgradations, my lord, the post of laboratory assistants was done away with. Now the petitioner was asked to, because he was having the qualifications of graduate and the B.Ed degree. Now,
Yes, Mr. Kundu. Ready?
Ready, my lord, no instruction has yet been received from any source of corner. Matter is 2008. I think, my lord, let it be decided on the basis of opposition and reply. Your
All
lordship.
right. You are ready with that?
My lord,
You are ready with the matter?
my lord, today I am not ready, my lord, all on a sudden, your lordship.
All right. Making not today only. Yes. Any recording will help you.
no, no, my lord, no, nothing will help me. Well, then keep it, my lord, after vacation. Because I'll be tentative, my lord, in the coming 2 weeks, my lord.
Oh, you want it after the vacation?
Yes, because I may not be here, my lord.
As prayed for by the learned advocate for the petitioner, list this matter immediately after the opening of this court after next month's vacation. Yes, next.
Fifty-eight.
Item number 58, I am for the petitioner, my lord.
Yes.
My lord, on the last occasion on 2nd September, my lord, I directed the respondent to file supplementary affidavit in opposition. My lord, that was served upon me last week. And I'm praying for 2 weeks time to file my reply to that.
Supplementary affidavit.
Yes, my lord.
The supplementary affidavit filed by the respondent numbers 1 to 5 is taken on record on the as prayed for by the learned advocate for the petitioner. Let an exceptions to the said affidavit be filed within 2 weeks from date. List this matter after 2 weeks. Yes,
My lord, only one thing, my lord. My lord, kindly keep this matter after vacation. My lord, the learned advocate on record is in hospital right now, so it will take time for the affirmation part.
List this matter after vacation. After
Deeply
next month.
obliged.
Yes, next.
Deeply obliged. Deeply obliged.
59.
The 59 minute I am for the petitioner. This matter was heard on the last occasion. But this is
Opposing you.
Mr. Ashok Kumar Jana is opposed.
Jana, yes. I think
So
it's led by Mr. Arunabha Ghosh.
I am also led by Mr. Somu Majumdar.
Passing it over. Pass over. Next.
60.
Pass over.
61.
Lord, I am from initiate. Lord, I am lead by Ms. Manika Roy. He is giving program number.
But he is not the so necessary party in this matter. Mr. Orko Nag is for the state. But I have served another fresh copy to him, and I had talked to him, and he said that he will come. And Mr. Shish
He will come.
Yes, my lord, this is the matter, my lord. This is the matter. State admitted that after
9CA was not.
the ninth was not served, and they said that fund was not placed. That's why no steps could be taken. This is number one. And the National Highway Authority, by filing state, they said that I was not asked to place the fund.
Yes.
This is the inter-department matter.
But fact remains, my lord, that after requisition, property, the land has been utilized, and this has been
Where is
categorical.
Mr. Nag? Because you have completed your, this is your submission.
Yes,
That
because
from the admission in the affidavit in opposition,
because my
no
lord, if
steps
you-
have been taken, but it has been utilized.
But you kindly, if you lordship kindly have a look at them, my lord. Kindly look at the affidavit in opposition once.
Yes. Of 1 to 5.
My lord, for all. Is there a respondent for the all the respondents,
Yes.
the state respondents?
Yes, 1 to 5, it has been said.
My lord, kindly see, my lord, 4 at page 2, 4B. Subparagraph B of paragraph 4. Subparagraph B of paragraph 4. Page 2 of the opposition.
Yes, possession taken.
Possession of the said land in question was taken over. Then, my lord, in view of the 80% compensation was paid. What is the ad hoc compensation? Then, my lord, kindly turn to, my lord, subclause E.
Yes.
It is also stated that steps to pay compensation have duly been taken. The acquisition case number being was switched over under section 9(3) of the Land Acquisition Act. But this is wrong. If you lordship kindly turn to
page 17.
Page 17. It's a wrong statement. Revised estimate under section 9(3).
Yes, I've seen that. Where is
Yes,
Mr. Nag?
Kindly take it up at 2, my lord. Again, I will inform him. Because I am the last occasion also, he took time. Kindly take it up 2, I will inform him.
All right.
Kindly take it up 2, my lord, I will inform him.
2 p.m. Yes, call the next matter.
Hmm. 62.
Pass over. Next.
63.
I appear for the petitioner in item number 63, your lordship.
63 मतलब तो hospital is appearing for the Union of India. There is a direction for filing the affidavit in opposition. Affidavit in opposition.
My lord, I am appearing for respondent number 2 and 5, my lord. We are adopting the affidavit in opposition filed by the Union of India.
Your lordship, I am being led by Mr. Vishwarup Bhattacharya. He is here, lordship.
He's a very busy counsel.
Well, busy in walking in the corridors and doing nothing and going to Milord.
Yes.
Kindly seize the affidavit. They have used an affidavit.
Yes.
Kindly
Ashok is my lord is leading in this matter. I am not the panic.
He takes it up at 2 p.m.
No, 2 p.m.
Your lordship has a bench at 1. Let us come back at 2.
Well, he has not come to the court. How the 2 p.m.
Huh? Okay.
Ashutosh Pathak আছে.
Har hoye.
Union of India along with
Dada
the
Opposition, Mr. Bhattacharya, have you prepared any reply?
Milord, perhaps Milord, a reply because yes, the gentleman. This is regarding Milord. This issue is traveling. Milord, let me come back at 2.
Then take back the opposition.
দুটোর সময় করো না।
My lord, fix it at 2. My lord.
There is another matter fixed at 2. This will be the second matter.
Great.
He has not come to court matter. Pathak.
Are you are here?
না না আমি থাকবো না আমি তো প্যানেলে নেই আমি ইউনিয়ন অফ দ্য রিপ্রেজেন্ট এএসজি is
ASG কে ডাকো।
ASG is taking
ASG কে ডাকো।
Yes.
Let the ASG come. Let the ASG come. ASG has the queue.
My lord, may I have your lordship's kind leave to mention, my lord, today's item number 9.
Appellate side.
Yes, my lord, appellate side under the heading to be mentioned.
Yes,
Pardon?
item number
Group
9.
9. Group 9. Sorry.
9 is not to be mentioned.
No, my lord, group 9 for admin.
Yes.
Admission, yes. My lord, the urgency is, my lord, the appellant before your lordship is the insurance company. Now, my lord, the writ petitioner has obtained order against the insurance company for payment the insured amount. Now, my lord, we have against that order, we have preferred an appeal. My lord, that is a subject appeal. Now, in the meantime, my lord, they have preferred a contempt applications, my lord, which is pending for adjudication. Now, on 2 occasions, my lord, the matter was heard and adjourned in view of pendency of this appeal, my lord.
When it has been fixed, when the contempt.
On 16th, my lord, of this month, my lord.
16th.
Yes. Only on 2nd December it was heard, and again, my lord, it was fixed on 16th of this month, my
But
lord.
today I have some difficulty, my lord. The order, my lord, impugned order is of 19th of February 2024. And today, my lord, it is mentioned as a very urgent matter, my lord. I don't know. A February order with a section 5. In any event, my lord, kindly don't fix it today, my lord. If your lordship wants to fix, my lord, and
Kindly
is
want to take
satisfied
it
with
up
the
today, my lord.
urgency of the February order, my lord, kindly fix on any other day, my lord.
Chakravarti, only one thing is urgency to be taken up today, and another thing is the matter is fairly at the top.
Yes, my lord. My lord, had it been taken up in the morning, my lord, I could have done it. I could have done it.
And you are also proceeding with the content.
My lord, I am not the. My lord, this is a matter, my lord, where I am not the petitioner, but my lord, I
But
have a
he
substantial
is
stake. I
appearing
am one
for
of the
one
respondents.
of the respondents.
But you are proceeding with the contempt application.
My lord, that is the petitioner is
He
proceeding.
is
my
not.
lord.
He is not the petitioner, my
I
lord.
am.
He is not the
Not the
petitioner.
writ petitioner.
No,
But,
no, no.
my lord, I believe that I have to make a
My lord,
substantial submission in
Sandeep
this matter.
Prasad Shah, Advocate Sandeep
representing
Prasad
him?
Shah.
I have given notice though.
My lord, we have given
The
notice.
learned advocate.
Sandeep Prasad Shah.
All right.
We have served notice upon him, my lord.
16th.
Yes, my lord.
So these matters are taken up on Wednesday. So next Wednesday we will be having a chance. These group 9 matters are taken up on
Monday and
Wednesday.
Wednesday.
Wednesday
Yes.
will be 7th. So let it appear in the list.
Lordship.
Deeply appreciated.
My lord, top of,
Fairly at the top.
my lord. My lord, kindly let it be, my lord, on the top of the list, my lord, on that day, my
At
lord.
the
Kindly.
top.
Lordship.
You want to get further up, go out of the list then.
No, no.
He wants a position between 0 and 1, my lord.
My lord,
Maybe half.
to mention one public interest litigation, my lord. My lord, here the urgency is this, my lord. The construction of a boundary wall is being done by the mass department, my lord, through the help of PWD, my lord. And for that, my lord, the pathway has been blocked, my lord, for 10,000 villagers, my lord, for of 10 villages, my
When
lord.
the construction
My lord,
made,
construction is being, my lord, for the last 1 week, my lord. I'm mentioning the matter, my lord. The public interest litigation has already been filed, my lord. My lord, may this matter be taken up, my lord, tomorrow, my lord.
will appear.
Tomorrow, my lord. My lord, but at the top, my lord. Otherwise, my lord,
Hand over the slip.
my lord,
Tomorrow before the regular bench.
deeply obliged. my lord.
Public interest litigation. You have filed.
My lord.
When have you filed?
My lord, before the honorable Chief Justice, my lord.
When? What is the date?
My lord, the date is, my lord, my lord.
This week, last week, when have you
My lord,
filed?
last week, my lord.
All right. Have you served up?
My lord, everybody has been served, my lord. In the meantime, I'll give notice, my lord, about the.
Tomorrow it will appear.
My lord, but my lord, at the top, my lord. Otherwise, my lord, at the top, my lord. Otherwise, my lord, because construction is going on in
What
full.
is the date you have mentioned in the presentation?
My lord, it is mentioned, my lord, on my lord, previous Wednesday, my lord, Thursday, my lord.
Previous Thursday it did not
No,
appear.
my lord, it has not
All right,
appeared.
it will appear
My
tomorrow.
lord, deeply obliged, my lord.
Yes. Any matter in the original side?
Item number 61 fixed at 2 p.m.
My lord, I have served notice upon them.
What did Mr. Nag say?
No, they said nothing. But I was asked to serve upon Mr. Shishanu Bandopadhyay. Then I served notice upon Mr. Shishanu Bandopadhyay.
Mr. Shishanu Bandyopadhyay is on his way, my lord. Mr.
Yes.
Shishanu Bandyopadhyay is on his way, my lord.
He's coming, yes.
No, my lord. This is the proceeding, my lord, which was initiated under the Act 2 of 1948. And possession was taken over on, my lord, possession was taken over 21st of December 1976.
21st or 27th?
27th December 1976, possession was taken over. And the purpose for which the possession was taken over is permanent in nature, and that has been constructed long back. Now, my lord, subsequently, my lord, nothing has been done. Act 2 expired. Now they were supposed to convert, if you want to continue with the possession or for the purpose of declare, they were supposed to convert this thing, my lord, upon service of notice under section 9(3) capital A. That was not done. My lord, when I moved this writ application, my lord, the Act 1 of 1894 stood repeal with effect from 1st of January 2014. Now, my lord, they have used an affidavit. They have categorically said that the possession of the land has been taken over, although they have stated in subparagraph E of paragraph 4 at page 3 that they have converted, they have switched over this under section 9(3)(a), but fact remains from the document they have annexed at page 17. Page 17, the notice which runs as follows, my lord, at page 17. This notice under section 9(3)(a) have not yet been served because the necessary fund is not available. Possession of the land measuring have been delivered to the RB on 27/12/76, and the requisition land has fully utilized. Then, my lord, next document. This is dated September 2002, 25th of September 2002. That they have referred some geo. I am not concerned with this, my lord. Even this shows that tentative date of service, date of notice under section 9(3)(a) is 27th July 2002. But fact remains, my lord, this has not been served. Moreover, till 31st December, 31st of January 2014, no award has been declared. And since the possession has been utilized, so, my lord, there is no other option but they have to initiate a fresh proceeding under the 2013 Act, because either way they have to pay the compensation. Neither under Act 2 of 1994 they can pay the compensation, not under initiation or any proceeding under Act 1 of 1894 can be initiated at this stage. So, my lord, I am saying, my lord, the compensation should be paid.
Yes, Mr. Bandyopadhyay.
My lord, your lordship will find, my lord. I'm not placing the writ petition, my lord. I'm sure my learned friend has placed it, my lord. Your lordship kindly takes page 6, my lord, of my opposition. Your lordship will find, my lord, the land was handed over to the requiring body, my lord, at the relevant point of time. That will be 1976, my lord. And the requiring body has, my lord, as is apparent from the subsequent documents, the land has been utilized by the requiring body. Now, my lord, your lordship, if your lordship kindly comes to page 10, which is, my lord, part of Art 2, the payment of compensation, starting from page 10, page 7. Your lordship kindly takes page 10, serial number 26. My lord, as far as, my lord, mushroom's sake is concerned, that is, my lord, the father of the petitioner. Your lordship will find, my lord, compensation has been paid.
Where is the award, Mr. Bandyopadhyay, whenever you declared the award?
My lord, as far as, my lord, the 93A is concerned, my lord, the award, my lord, your lordship will find that
Mr.
80%.
Bandyopadhyay, either because initially the proceeding was initiated under Act 2 of 48.
Fine.
Have you declared any award under Act 2 of 48?
Yes, my lord, as I find, my lord, 80% of the compensation has been paid.
That is, Mr. Bandyopadhyay, you are obliged to pass an award. Have you passed any award?
My lord, that document, my lord, is not there in the record, my lord. That there, my lord, I cannot.
What
make
is
that
your
submission.
answer to your opposition at page 17? Document at page
Yes, my lord,
17.
I cannot go beyond the records, my lord. As far as 93A is concerned, notice has not been served because
the
fund has
proceedings has not been culminated.
Fund has not been placed by the requiring body, my lord.
Yes.
Now, my lord, an affidavit has come saying that we have nothing to do with the utilization of the land, my lord. That is, my lord, filed by.
No, according to the NHAI, they say that we approached the PWD. They have not given any estimate. For that we could not place. It's an interdepartmental issue.
Right, yeah.
Sort it out.
But the
landowners have to be paid the compensation.
But 80%
And you have the authority
compensation
to
has
pay
been
the
paid.
compensation.
80% compensation has been paid.
Mr. Bandyopadhyay, it's not the, you have to pay the entire amount and you have to pay the amount as per the award. Unless you declare an award, nothing.
But my lord, this situation
Whatever you will do with that 80%, how have you calculated 80%?
Well, the situation today is such that, my lord,
Bandyopadhyay, this amount of compensation has to be calculated in the award. If there is no award, how have you calculated the compensation and what is the basis of that 80%?
And they will not be able to
You may
challenge
have
it.
paid something. You have may have paid something. But for that, can you say, no, I'm not obliged to declare any award?
I cannot make that submission, my lord.
What do you want to do now, Mr. Bandyopadhyay? Because if it is not acquired, we have to take fresh steps. And I do not know whether Mr. Pan will be agreeable to that. In one of the other, another matter, there was a proposal from the state, similar case, that they want to pay an amount as per the direct purchase policy.
I'm sure Mr. Pan will not agree.
No, so in that case he agreed, Mr. Pan, but in this case he is not agreeable.
Well, then, my lord, I'll have to take further instructions on that, my lord. But
instructions
will not better the records. It
Yes.
will not better
So
the
if it
records.
is not better the records, either Mr. Bandyopadhyay, you have to take fresh steps for acquisition, to do whatever you want, or to release
in
the
that
amount,
case, my lord,
or to release the lands.
But with the understanding that Mr. Pan is not agreeable for direct purchase in this matter, my lord, let me.
I have no question of my agreeable. They have to offer first, then question my agree. Now, my lord, I supported something, another thing. Mr. Bandyopadhyay must be aware. An order was passed. I agreed to that order for direct purchase by another advocate, state paper and appeal, saying that he was not authorized to say this, to make an concession.
Mr. Pan, if your client is agreeable, I will not merely on the statement, some responsible officer has to come and affirm an affidavit with regard to that.
Yes.
If you are agreeable to that, and if an offer to that extent comes from Mr. Bandyopadhyay.
Yes, in writing. In writing.
Yes, if you say so, I can direct one of your responsible officers to affirm an affidavit with regard to that.
But kind of not record it today. Kind of not record it today, because today, my lord, we are in a discourse, my lord, if I may use that word, my lord. But it fell from the bench, my lord. I am responding to the bench, my lord.
No.
So, my lord, before.
No, Mr. Bandyopadhyay, this is one of the options available.
Yes, my lord,
the
let me come
thing
back
is that you have to acquire the property. So
either way, yes.
In that course, by way of compensation, instead of acquiring, you can make an offer to him.
But
it is up to him to accept that or not. That does not require an order of the court also.
Yes, but today my submissions is from the bar. It's not like my officers have instructed me.
No. I will not.
That is what I'm saying.
No. I will not record. If you have that instructions on that, if you have that instructions, then I will, in order to protect you as a counsel, I will direct some responsible officers to affirm an affidavit. But provided you have that instructions with
not today, I am not having the instruction today.
I'm making this submission because I understand the difficulties as far as 2013 Act is concerned as well, because we are making that submission in other matters as well. So, my lord, kindly allow me to come back with that. I'll try to impress upon my officers that to make the offer or give me instructions to make the offer in writing.
No, instead of that, if you have an offer, you can directly make an offer to Mr. Pan's client.
In the meantime, we can do
In
that. In
writing.
the meantime, we can do that.
But for that, I have to record your submission with regard to that. Otherwise, I
But
cannot.
kindly do not record it today, my lord. Kindly keeps it, my lord, on in the coming week, my lord. Whenever your lordship sits, my lord, I'll come back and make the submission.
Yes, my lord, I am agreed to that. And moreover, my lord, only one thing for my satisfaction, subject to your lordship confirmation. It has been submitted on behalf of the state that 80% of the compensation, possibly that is not the correct. It's an estimated value.
No, that Mr. Bandyopadhyay understands it very well. He has said some
advance payment.
80% advance has been made.
Yes.
So,
But
he is
yes.
not so vociferous on that. He has made because the documents reveal that.
Yes.
He has only referred to that.
Yes.
He is not vociferous on that. He has only referred to that.
So may I pay one indulgence before your lordship, my lord? Let it appear under the heading continuing matter.
How that will help you?
Well, that will help us a lot.
Continuing matter heading.
The possession of the lands in question was taken on December 27, 1976, pursuant to a proceeding initiated under the West Bengal Land within bracket Requisition and Acquisition bracket closed Act 1948 within bracket Act 2 Roman 2 of 1948 bracket closed. Mr. Pan, learned advocate appearing for the petitioner, submits that no notice under section 4 within bracket 1A of Act 2 of 48 was served upon the petitioner. In the meantime, the 1948 Act stood repealed. No step was taken by the state to acquire the lands in question by resorting to the provisions of section 9 within bracket 3 capital A bracket closed of the Land Acquisition within bracket West Bengal Amendment bracket closed Act 1997. Paragraph. From the affidavit in opposition filed by the state, memo dated 973/EN, E capital N small / LA, dated June 28, 2002. From the affidavit. Now, from the affidavit, in the affidavit. Such and such has been annexed. It is evident from the said memo that notices under section 9 within bracket 3A have not been served because the necessary fund was not available. It further appears from the said memo that the requisitioned land has been fully utilized. On a query of the court, Mr. Bandyopadhyay, in his usual fairness, submits that he is not in possession of any document to show that the award has been declared. However, he seeks an accommodation to assist this court on the next occasion. Friday, Mr. Bandyopadhyay?
But kindly don't keep it this week, my lord, because I'll have to. It's an old matter, my lord. They will also have to consult the records, my lord. Kindly keep it next week, my lord. Whenever your lordship sits, my lord, we'll be there.
List this matter on 9th of December 2024 under the heading Forwarders at the top.
Madam, obliged to lordship.
আচ্ছা আচ্ছা একটা এই রেকর্ড এনএইচএ আছে হার্ট দি লার্নেড ওটা রেকর্ড করে দিন নাহলে হার্ট দি লার্নেড অ্যাডভোকেট ফর NHAI on such submission. Yes.
63. PM.
ASG has not been come today, so duty is illness.
Does not come today.
And advocate on record also asked to my lord the at least my lord, after the 18th my lord, maybe matter will be taken
After
up.
18th?
After 18th.
Let the matter not be taken up.
But
My lord, at their mercy, my lord, I cannot suffer. I am suffering for the last 28 years. Your lordship hears what the matter is. My lord, it's regarding a particular course being recognized.
Look at the embarrassment. You are putting the court into embarrassment. You
And
have
what
not
is their
informed
stand
Mr.
in the
Bhattacharya
affidavit?
earlier. He is come. He has a right to oppose your prayer for adjournment. Look.
No,
at the
kindly
embarrassment of
record
the
that I am opposing. I might lose, but my lord, kindly, my lord, this matter needs to be heard.
very fast morning, my lord, the clerk is also present of the ASG. My lord, similar situation I have been informed, my lord, he has not come to court due to his illness, and advocate on record is not available.
And he is carrying the affidavit.
Carrying the file is.
He is carrying the affidavit.
I cannot say this man, no legs to stand. I have the union of
that he is
India.
not in this matter because an authority
Kindly,
of
kindly,
India that is
my lord, what is the subject matter, my lord? May I just indicate to your lordship? My lord, it is regarding biochemic, my lord, medicines, system of medicines, whether it is independent of homeopathic medicine or not. That is the sum and substance of the writ petition.
I appreciate that, but Mr. Bhattacharya, they have to be hard.
Keeps it next week then in that event. The week beginning 9.
My lord, the advocate on record is available. My lord, without advocate on record, the ASG is not cannot do. This is my.
Well, let them change. Let them obtain a change.
The advocate on record will not be available.
Now he is out of station, so he has given the brief and to talk to.
With a very
given the brief to you. So now you are the advocate on record now.
No, I am not the Union of India member.
That can be taken care of by the learned ASG. Where is the learned
Central Council of Homeopathy is here.
Where is the learned ASG? Has he come to?
No, he has not come to court.
All right. I think that may not be a problem when the learned ASG is appearing. That can be regularized.
My lord, affidavit will be taken into consideration.
No, if you say so, I will proceed with that. If you say so, I will proceed with that. An accommodation has been paid for.
A supplementary affidavit to file for it.
Heard Mr. Bhattacharya, learned advocate for the petitioner. An accommodation has been paid for on the ground of the learned ASG. To stop, list this matter on December 9, 2024.
As an indulgence, if it is.
My lord,
Mr. Bhattacharya,
but I am not
substantially hard. I can keep it.
No, not part hard. I am saying, if it can be, a little higher up in the list. Otherwise, it will be taken up post this. Kindly
consider. Yes. Oh, heard the learned advocate for the. Heard the learned advocate for the respondent number 25. Give your appearances. Yes. Call the next matter.
64.
Oh, এটা কোনটা এইটা বোধহয় সেই আগের ম্যাটারটা ছিল মিস্টার পান দিচ্ছে এটা দিয়ে দিন নাহলে ওটা about the appeared.
Your Lordship, I'm appearing on behalf of the petitioner. I'm led by learned counsel, Mr. Onindo that he could not come to the court today as he's suffering from cold and cough. So praying for not today.
Not today. Yes, next.
One thing, they have served me copy of the reply, but
so you want to file an rejoinder to the reply?
Only yesterday. Yesterday, they served my copy.
Yes.
So kindly allow me to some time.
What
to
is the
consider.
matter?
No,
Disciplinary
DCA
proceedings.
proceedings, my lord.
Disciplinary proceedings, affidavits cannot improve. The documents, you are the custodian. So you prepared yourself on the basis of the documents. Reply. Don't take this plea before this court. Disciplinary
65.
proceedings, affidavits not necessary.
65 to 67.
Yes.
I am for the petition in this matter. Pursuant to your lordship direction, my lord. This is my supplement. Supplement.
Who is opposing you? Land acquisition.
My lord, this is the proceeding initiated under the Metro Railway Works and Construction
Who is
Act.
appealing?
Shubhankar Chakraborty and Srijani Ghosh.
Where are they?
Shubhankar Chakraborty.
Where are they? Mr. Pan, if you can call, I can take it up. Ex party.
No, my ex party, I don't want to do this.
Passing it
because
over. Pass over.
Pass over.
Keep it with you. Keep it with
My
you.
lord. My
Pass
lord.
over. Yes. What is that? Supplementary affidavit?
Supplementary affidavit.
So have you served them a copy?
Yes. Well, within time as well, lordship direction. Only the annexing the documents which are of the grounds of appeal in the before the appellate authority.
That matter.
That matter. That.
Yes. Call the next matter.
68.
Pass over.
69.
Lordship, Mr. Shayan Sinha is appearing on behalf of the petitioner.
Who is appearing?
Mr. Shayan Sinha.
Yes.
Lordship, due to some personal difficulties, he is not here in court, Lordship. For that reason, I am praying for today.
Not today.
Not today, Lordship.
Not today. Mr. Gupta, you are appearing in this matter.
69.
You are appearing in 68. Nobody appeared for the. You are for the petitioner. Or you are for the
authority.
That is the petitioner. Where is your other side?
In the presence of the other side, I would pray for leave to file a supplementary. Because I find that documents are absolutely necessary.
You can make that ready.
But if it is taken up this week, possibly it will not be.
If it is
Taken up this week, I cannot possibly.
So you are praying for an adjournment for this week.
Yes, for this.
As prayed for, 68 at a order record করে দিন. As prayed for by Mr. Gupta and its senior counsel for the petitioner. Hearing of the matter stands adjourned for this week.
You have to enable me to file a supplementary affidavit.
You said that you will make that prayer in the presence of the other side. That is why I have not read. You can prepare. You can make it ready. If you want, you can serve them a copy subject to any objection that may be taken up at the time of hearing. If you are annexing some documents only, I think
Only some
they may not raise any objection. Prepare it. You can also serve them a copy so that it can be taken up subject to any objection that can be taken at the time of hearing. Yes, call the next matter.
70.
You are for the state. Who is for the petitioner? Mr. Kormakar, you are for the petitioner.
My lord, my learned senior is engaged in court number 24. She is on her leg. My lord, praying for.
Who is your senior?
Devjani Shanmugha.
Pass over. Yes, next.
71.
Lord, I beg to appear for the petitioner in this matter. Lord, affidavits are completed.
Who is opposing you?
Lord, the state was there at one point of time. Mr. Lord, Lord, I find Mr. Manos Kumar Sadhu Milord is appearing. The issue is with respect to Lord whether even after expiry of the sand mining lease, I am entitled to an extension exercising my rights under the force majeure clause. That's in gist.
Renewal.
Renewal. I am not saying renewal, I am saying extension.
In whatever name you say, so is the writ maintainable for that?
Lord, I would say yes.
For extension of a lease.
Lord, here, yes, because it's completely
Private contract,
No, it's not a private contract only, it's backed by statute.
statutory contract.
Yes, backed by statute, backed by statute. It is because of the statute that the contract exists. It's a government grant.
Not a statutory contract.
It's a government grant. It's a grant under section 3.
Who is appearing for the Mr. Sadhu?
My lord.
Sushobhan Sengupta, Ayan Banerjee.
Sushobhan Sen. Yes. My lord, they were appearing, my lord, throughout, but
They are not appearing now.
I do not know, my lord. The affidavits are on record. The matter is running in the list, my lord, since I have mentioned this matter, my lord, upon notice. What else, my lord, can
You want to proceed ex parte, Mr. Kormokar?
whatever lordship feels, my lord, I
Inform them if you can bring them.
Lord, then kindly fixes the matter, my lord.
Please fix Mr. Kormokar. Pass over next.
No, pass. Lord, lordship's direction to pass an order, my lord, so that I can communicate.
Heard Mr. Kormokar, learned advocate for the petitioner. None appears for the respondents. The learned advocate on record of the petitioner is directed to communicate the next date of hearing to the respondents or their learned advocates and file an affidavit of service on the next day. When? Next week?
Next week.
This matter under the same heading.
Great.
Next.
72.
If 72 and 73 is a tagged matter, Lordship.
Yes.
In this matter, I'm led by Mr. Shobhushaji Chatterjee. He's on legs. So the circuit, not Bengal circuit, but Lordship, I shall. I will continue. I shall continue, Lordship.
So Bandhavadda for the state.
For the state led by learned advocate.
Yes. The learned advocate jail is available.
But he's available. He's available.
He will be joining you.
Yes, well, hopefully, my lord. If not, my lord, I'm there.
All right.
His Lordship, on the last occasion, Lordship heard me. It is the matter.
Heard this matter. What is the issue?
The issue is, Lordship, I am a contractual employee appointed by the Food and Supplies Department for the period of 6 months, Lordship. In the meantime, they have issued another notifications. By replaced me, they have tried to engage another.
One set of contractual employees by a different set.
By DEO, yes, Lordship. Data entry operator. Lordship heard me on the last occasion.
Have you brought those judgments?
Yes, Lordship.
These data entry operators, are these posts sanctioned posts?
The data entry operator?
You are for the data entry operator?
Yes.
Are the posts sanctioned?
Lordship, that part, I don't know whether it is sanctioned or not, but I was appointed by them.
Which you will be relying on this will be appointment on contractual appointment against sanctioned posts. I think those decisions you will be relying upon.
Yes, Lordship.
Out of your case, that one set of contractual appointees cannot be replaced by a different set, but in those cases, appointments were made against sanctioned posts.
My point is
subject to correction.
Yes, my point is, Lordship, I was appointed by the Food and Supplies Department directly through a procedure examination.
Sanctioned posts. If not, what right do you have?
Yes, Lordship, the right is there in the notification itself. They have stated that re-engagement can be done if there is requirement.
If there is requirement.
The requirement is there, I shall make the case at the time of hearing. Yes, requirement was there.
Are you requirement according to him is there? If there is requirement, why are you replacing one set by a different set?
Not.
When you are not proposing to give a regular appointment.
We are not replacing apples with apples. We are replacing apple with oranges, my lord. That is the case. The purpose for which my learned friends' clients were taken the time period for which it was taken is completely different from this new set for which we seek to appoint. This set of 597, which my learned
All
friend-
right, let me hear him.
Yes, the purpose, our case is that the purpose is different, the tenure is different, the approval system is different. It was absolutely an additional ad hoc task force for a
So
particular
according
job.
to you, it's not a case of replacement by
No,
one
it is
set,
not.
but different set.
Replacement by a different set, and this set, the approval channel is completely different from the funds where it will be.
But is
they
it
will
for the
pay.
same post, Mr. Bandyopadhyay?
Well, maybe the nomenclature may have some similarity, but the nature of job is completely different.
Nature of job different. Have you disclosed that in your affidavit?
Well,
of
yeah,
opposition?
for your lordship, first query with regard to sanction, it is there in page 4 of our affidavit in opposition. And my lord, with regard to the difference, my lord, that also paragraph 4, subparagraph 5.
You have stated that in
7,
your
8.
affidavit. All right. Yes.
Yes, Lordship. On the last occasion, your Lordship asked me, this is one question, that whether at the time of my tenure, the later on notification which they have published, Lordship may kindly come to page number 146 of the writ petition.
Page 146. Yes.
Yes, Lordship. Lordship, the second last paragraph. This has an approval of the finance department, UO number group such and such dated 23rd of March 2022.
So show me your initial appointment. This has been filed by a group of persons.
Yes, Lordship.
Yes. Show me any of.
Lordship, that is appeared in page number 62 onwards.
Any one you can show.
Page
62.
62, 63.
All right. So all are same.
Yes. Yes, Lordship. Against the notification that is also annexed in annexure P1, and the one single paragraph which is in our favor.
Temporary additional data entry operator.
Yes, Lordship.
Contractual hiring basis.
Lordship, the nature of work was mentioned in the order that we can get from the page number 57.
Page 57.
Yes. From there we can get the nature of work.
Yes.
That shall I read, Lordship? The department has decided to engage temporary additional data entry operator for district level offices on contractual hiring basis from ensuring prompt and time bound services related to duare ration card, life cycle management, paddy procurement and other regular establishment work for a period of 6 months from such and such date against monthly consolidated remuneration of 13,000 rupees. Basic objective relatives, the inquiry and supervision of work, whether basic and routine can be performed by the DEO. The candidate shall be selected as per the eligibility criteria as per laid down in the memorandum of the finance department 5859 such and such shall take in prompt action for the selection of the engagement of the DEO. Lordship, kindly come to page number 59 once.
Yes.
Paragraph 5. That is 5859, which is mentioned in there. Shall I read, Lordship?
Yes, yes.
Contract for engagement of manpower can be done by the department or directorate purely temporary basis for a period of 1 year or less. Development and implementations of e-government projects which can be renewed on monthly or yearly basis of the head office department as per requirement of the project. Therefore, Lordship, it can be renewed. And our contention is the requirement shows the subsequent notification which has been published for the same post, that is data entry operator.
Where is that?
Yes, Lordship.
Notification?
That has been stayed, Lordship, in page number 144.
This has been stayed.
This has been stayed
by the interim order.
Yes, Lordship. I'm enjoying an interim order.
Yes.
That is in page number 144, Lordship.
Yes.
Placing the services of data entry operator in various offices under Food and Supplies Department of temporary
Give
basis.
me a minute. Yes.
144, Lordship. Placing the services of data entry operators in various offices under Food and Supplies Department on temporary basis. Food and Supplies Department, West Bengal requires the services of 342 data entry operators. That was my post, Lordship. In various offices under Food and Supplies Department on temporary basis. Out of these, 244 DO are required to be engaged in the field officer, directorate of DP and S, while the rest of 98 will be assigned for various work under directorate of rationing. The temporary temporary basis for 1 year or till requirement is over. Whichever is earlier, this DO will assist the office staff or perform duties in the office for data entry, scanning document, processing of initial work relating to the ration card, Lordship. I was doing the same job. And other online services in the portal, the field offices are located in various blocks, municipalities, subdivisions, and district headquarters where these DOs will be required to provide this service. Now, Lordship, kindly come to page number 146 for once, Lordship.
Yes.
The second last paragraph. This has an approval of the finance department by the UO number group such and such dated 23rd of March 2022 and the competent authority. Therefore, Lordship, that was within my tenure. This shows the requirement was there for the post of DO. But one thing I must clarify before this bench, I am before this court not for any regularization or nothing. Till the regularization or the regular appointment they have done, I am having the experience. Kindly allow me to work. This much, Lordship, nothing more, nothing less.
Yes.
Therefore, the requirement which it shows there, it shows the requirement was there, Lordship. And on the last occasion, at the time of hearing, which I have shows from my affidavit in reply, Lordship, that is the numbers in the Duare Sarkar. It is a continuing process. Duare Sarkar camp that is initiated by the government of West Bengal, that is a welfare scheme. That is a continuing process, Lordship. Each and every time, huge bundle of ration card came before the Duare Sarkar camp also. Therefore, Lordship, my humble submission before this court, Lordship. I am the experienced one. I am having the experience of 6 months. And moreover, Lordship, the notification itself speaks itself.
Contractual period was till when?
To June. June of 2022.
June of 2022.
Yes, Lord.
Thereafter, your allegation is that, or your grievance is that it has not been subsequently renewed.
Yes, it may not be renewed if this notification was not there. Yes.
Your grievance is that it was not renewed. On the contrary, some other persons are being taken.
Yes, Lordship. And moreover, that is also from the WTL, whereon WTL that is Webel. WTL that is Webel, wherein, Lordship, I was appointed by them, by the Food and Supplies Department, by the examination and by the process. We have to follow the process. It was not that pick up choose.
Examination was conducted.
Yes, computer examination was conducted, Lordship.
Yes.
And thereafter, Lordship, only my appointment was done. My respectful submission before this court is, Lordship, when I was being appointed by the authority directly through the examination, that was within the 6 months. That is for the time bound period, that is for the 6 months. But this subsequent notification, Lordship, that gave a clear message that requirement is there. And if requirement is there, I have shown.
The appointment made pursuant to that notification, no.
No, that has been challenged and that has been subsequently stayed.
So no fresh appointment now.
Has been done. And Lordship, as your Lordship asked for the judgment, I have the judgment, but prior to that judgment, Lordship, I am covered by the notification itself, which says if there is requirement, renewal can be done. And I have shows that requirement was there, Lordship. If there was no requirement, there was no case at all. This is my case, Lordship.
So Bandyopadhyay, you have a requirement of data entry operators. Maybe you are styling some different name, you have evolved a different procedure. But if data entry operators, they will only do these data entry jobs. Whatever jobs you will assign, they are capable of that. Unless you have something in particular against any of them. So why are you not re-engaging them?
No question of eligibility.
You may say, no, they were for this project at X place. Now the work will be at Y place. If they are willing to go at Y place, well and good.
The question is other.
Because the nature of the work which these data entry operators will do.
Completely different. Completely different. Where they will be posted is different. The channel of approval is different. And more so, if it is the submission of the petitioner
Yes, I
that I
accept.
am eligible, then no one is stopping them for applying under the new requirement. If one person is eligible, what he wants to do today, he wants to curtail the competition. He wants to curtail the competition by saying that you take this 342 from this my group of 600 only. Do not throw it open to the general public. Do not let anyone else come in. There should be no competition. Today, your requirement is, my requirement admittedly is lesser today. Assuming every parameter is same, every parameter. Taking what is falling from your Lordship, that the job is same. Let us assume for a moment, for argument's sake. Today, my requirement has diminished to 340. They are
just diminished.
342. They are 600.
Initially,
they are 597.
497.
Petitioners are 497. So it's a lesser.
Petitioners are 497.
I can give the exact figure, Mala.
Yes, court fees.
Paid.
All.
Yes, Lordship. For that, thereafter the interim order. No, not 497.
597 is the group. Group is 597.
Yes.
So all these petitioners have paid the court fees.
Yes,
Why?
but Lordship,
Why they will be allowed to be joined in one petition?
Sorry.
Petitioners are
Lordship 161. That is in
160 for 161 lead petitioners, you have paid court fees.
Yes, Lordship. All court fees has been paid.
All court fees.
Yes, Lordship. Thereafter, the interim order has been passed.
So beneficiary is beneficiary of any order that may be passed.
All right.
497.
597. This initial notification says 497. All right, let us take it as 597. So now you say that your
mistake in my notes, it is 497. 497.
So
the requirement has diminished. So the ultimate, what the goal of the petitioner is that do not throw this 342 new requirement posts to the public at large. You restrict it to my group of 500 people. You take your 342 from my 500.
What is the selection process? Is there any selection process?
No, but the eligibility criteria is there. That is, your lordship will find that.
No, eligibility criteria, let us assume that they fulfill that. Is there any selection process? How you will select?
Selection process is to be taken up by Webel, because we are not taking it directly. We have instructed Webel to take it in terms of our requirement. And our requirement is there at page 144.
So they cannot directly participate in any selection process because you are not conducting any selection process.
So, go and apply it for Webel. When
Webel, Mr. Bandyopadhyay is not here. So Webel will not be bound by anything unless you take responsibility and say, yes, they will be allowed to participate in the selection process through Webel.
Okay. And thereafter, the shortlisting that Webel will give us, but we will ask these candidates to undergo some tests.
Some
tests.
That is training.
Test. The test.
Training or test.
Hands-on test.
So you will you have a right to reject some of them.
Yes. They will give a shortlisting to us.
Thereafter you will select.
Yes. We will give a test to them on typing, Word, Excel, PowerPoint, proficiency in the use of internet, handling of email, data entry, and interview to finally prepare a list of DEOs to be sponsored.
Where is that? Where is that? Where is that?
145.
of the writ petition.
Of the writ petition, that my learned friend was placing 144, I am placing 145. Second page of that document. 145, I will take from the third paragraph. After shortlisting,
Yes.
after shortlisting of candidates on the basis of documents, checking whether they satisfy the eligibility criteria, etc., if candidate sponsored by WTL would be required to undergo a hands-on test on typing, Word, Excel, PowerPoint, proficiency in the use of internet, handling of email, data entry and interview to finally prepare the list of DEOs to be sponsored by each district DDR as per the required number.
Who will conduct this test? Who will conduct?
After WTL makes the initial
Shortlisting.
and brings it to us.
All right.
WTL shall make available district-wise of DEO who the concerned DCFS or DDR will choose the subordinate officers for which each DEO shall be engaged or will perform the services. Here, I'll just pause here for a moment. This paragraph is there because your lordship has seen in the paragraph my learned friend read. His appointment is in the central district offices.
His appointment is in?
Central district offices. District administration office.
Yes.
This new recruitment is in the field level offices, blocks, municipalities, etc. It is at a much more grassroots level. So that is what I submitted, my lord. The area of operation is different. The nature of work is different. How these people will enter is different. And I also show when I place the other paragraphs of my academic document, everything is different. The only goal is that do not throw it open to the public. Do not let other people proficient in these works to come in. I will steal a march over everyone, showing an experience of 6 months. This is the goal. Because the state is not restricting anyone. We're repeatedly making the argument of welfare state, etc. State is not restricting anyone. This 497 is equally welcome to apply if they are not over 40 years old. They can apply if they are proficient in these works. There is no difficulty in that. But if there is no extra marking or extra advantage for experience, then this experience cannot be harped on because the nature of job is completely different. Now, my lord, kindly.
But experience, Mr. Bandyopadhyay, they are entitled to some marks on experience. Very recently, the Honorable Supreme Court has said, even working in contractual posts, even experience, some weightage is to be given. So why we will not give them weightage?
The employer has to be given the elbow room to fix the eligibility criteria.
Yes, but weightage on experience.
But that is why I submitted. If the job, if I am not taking apples for apples, if I am taking oranges for apples, then the question of this experience may not be there. If the person is experienced enough and he is fit for this next job, new job, he will be much more proficient in these works.
Experience in the new notification, or in the subsequent notification, that also in the Department of Rationing. What is the nature of job they will do?
It may anything and everything.
So if the nature of the job, have you disclosed in the affidavit in opposition, what are the jobs which they will have to
it is there in page 144 itself. Can you take page 144?
No, that is the broad thing. What are the items of work which they will have to do? What is the data entry, from where, what type of data entry they will be required to?
144, it's apparent from the memo itself.
Yes.
144, first paragraph.
Yes.
Starting with food and supplies department.
Yes.
Can you take the last 5 lines?
Yes.
These DEOs will assist the
You can place the sentence just before that. Out of these 244.
I'll start from the beginning.
Yes.
Out of these 244 data entry operators are required to be engaged in field offices under the Directorate of DDPS, while the rest 98 shall be assigned for various offices under the Directorate of Rationing.
What they will, this 98 will perform under the Directorate of Rationing.
Job is same.
Yes. If the nature of the job is same, and they have, these particular petitioners have acquired some amount of experience.
Same as the 497, same between 244 and 898. When I say same, I say 244 and 98 has the same job, which is designated just below that. Just below that.
But according to you, this 98, who will be assigned the jobs under the Director of Rationing?
Difference is FPS and kerosene. One is food grains, one is kerosene. Directorate of Rationing is dealing with the kerosene.
The only data entry operator, they will only record this, upload this data, from where
As
this
distinguished
food
from-
grains or kerosene, how it matters, Mr. The basic knowledge and the expertise that is required, that may not differ.
244 and 98 has the same job.
But how do you say this work of 98 is different from the earlier contractual appointment?
I'll show it. I'll show it. Kindly allow me to read their article. These data entry operators will assist the office staff and perform their duties in the office of data entry, scanning document, processing of initial work relating with ration card and other online services in the portal.
Yes.
The field offices are located in various blocks, municipalities.
That is where it is located.
District headquarters and so on.
Yes. Now,
Then,
pausing
then-
here, only
then-
one, without interrupting you, these DEOs will assist the office staff or perform the duties for data entry scanning. What were these petitioners doing as per the earlier thing?
Can you take the earlier one, Manoj, page 57?
Yes.
The 57 year also got it. The department has decided to engage temporary additional data entry operator for district level offices on contractual hiring basis for ensuring prompt and time bound services related to Duare ration card life cycle management, paddy procurement and other regular establishment work for a period of 6 months and so on.
Have you disclosed in your affidavit what was the nature of duties they were performing? You have given some schemes. Duare ration, names of some schemes you have said. What were the jobs they were performing?
Basically, multitasking as distinguished to the specific work mentioned at page 144.
How do you distinguish? I want to know that. How these two nature of job is distinct, different from each other.
Find any specific or stringent eligibility criteria in page 57. As opposed to those requirements which is in page 144, that they will have to, no test has been conducted because it is very for a very temporary nature it has been taken to meet the then requirement. Your lordship will not find any test at page 57. The old requirement, no test, no eligibility criteria.
Only one thing, if the petitioners are agreeable to participate in these tests, because the initial shortlisting is by Webel or WTL, whatever you say. So how or will these petitioners be allowed to be enrolled themselves under WTL
Yes,
for the purpose of shortlisting? How? In what manner?
And this takes page 144 again. If they fit the eligibility criteria at page 144,
So they have to apply before the WTL.
yes, that is always open to them, but they do not want that.
All right. Are you agreeable to apply before the WTL for your enrollment? You will be considered for shortlisting.
For the subsequent notification?
Yes.
By the WTL?
Yes. You will enroll, you will participate in the selection process. On the basis of merit, you will come.
First come, first lordship. I was
I'm
appointed.
asking you.
Yes.
I will go into that. Are you agreeable? Do you want to take instructions from the petitioners on this? Whether
Yes.
they are agreeable to be enrolled, to enroll themselves with the WTL?
I need to instruction from my client.
That is so.
This is one part lordship. On another part lordship, I just as to cut out the entire competition. That was the contention from the State Council lordship. To cut out the contention. That was not my case lordship. The
You
notification.
participate. Now you want jobs. So you are in X job. So now you can participate in that.
Yes, lordship, but the memorandum says that
Now,
can be
for the
renewed.
present- For the present, you are unemployed. You are not getting any remuneration. You are not employed anywhere. So the question of renewal, if allowed, will be from the date subsequently. If the court allows thereafter contract renewal. For the present, are you willing to enroll yourselves in WTL to get yourselves and to participate in the selection process? That Mr. Bandyopadhyay says he has no objections. You can be allowed to participate.
Yes.
Are the petitioners? I'm not on 497. Are the petitioners willing to participate?
Yes, for that lordship, I have to take instruction.
Take
For
instructions and
that,
come.
but lordship, just
that might shorten this litigation.
Yes, Lordship.
Invite your lordship attention to page 140, their representation, what they want.
Then your grievance goes, you will be allowed to participate because these persons are not being automatically engaged. According to the 144, 145, there is a process. So if you are allowed to participate, you can take your chance.
Yes,
there.
Lordship, but the notification, the memorandum upon which I has been appointed has been done. That clearly says upon the paragraph number 5 that I have placed before this court,
For
contract.
renewal.
Yes, Lordship.
So you want renewal, you don't want to participate, take that instructions. Then I will consider the case on merits. Then you cannot then fall back and say,
Lordship.
allow me to participate.
Lordship, very clear, Lordship. An unemployed man is want employment, nothing more, nothing
If you
less, Lordship.
want to
Yes.
take instructions,
But that can be
come
passed
back
upon
on
the
that.
employer. That can be passed upon the employer.
No, Lordship. Nothing, Lordship. Just I want my job back. Nothing more, nothing less.
That is a different thing.
No.
One thing, you want your job back.
Yes,
One
yes.
thing, you will get a job.
Yeah, I will get the job.
Different things.
Yes.
Whether you will be getting back the earlier job or you will be getting a job. That is the difference. So you are interested in getting a job.
What is fallen for you, fallen from your Lordship? Let me take instruction from my client, then I shall back.
After some argument, the learned advocate appearing for the petition, I'm not indicating anything, take instructions and come. After some argument, the learned advocate appearing for the petitioner seeks time to take instructions in this matter as to whether the petitioners are willing to get themselves, Mr. Bandopadhyay, they will have to get themselves enrolled in WTL.
Yes, my lord. First, but yes.
To get themselves enrolled with WTL sub capse, WTL so as to in order to participate in the selection process proposed to be undertaken for appointment to the posts of data entry operators in various offices under Food and Supplies Department on temporary basis pursuant to the notification dated 24th of June 2022. Yes, how soon?
Within 3 days. Next week, Lordship.
Next week.
Yes, Lordship. Lordship, can it be fixed, Lordship? Any time as per the convenience of this court. Any time.
Yes, I have seen a lordship.
Yes, Lordship, but
Goes through the
yes.
most of the
Next week,
As
Lordship.
paid for the as paid by the learned advocate for the petitioner, list this matter in the next week. Next week? Yes.
Lordship, can it be part heard?
Part heard. I've said after some argument. So I've heard you.
Grateful, Lordship.
Two matters.
Yes, Lordship, this is tagged matter. Both. 70.
Why? That is a different group.
Yes.
Another, how many more?
140, I guess.
140 more.
Yes. They have also court fees, Lordship, paid.
দুটো আলাদা আলাদা উইথ করে দিন সেম অর্ডার yes next
Grateful, Lordship.
74,
pass over.
74.
74 you are for respondent
bank.
What do you want?
Sir, our senior Mokaram Hossain is appearing in this, but he left this court for emergency.
Not today. Not today করে দিন. Yes, next.
76,
Not today. Next.
77,
Next.
78,
My application.
Yes.
Finally been able to catch hold of
Mr. Prasad.
Mr. Prasad.
You could catch Mr. Prasad or you could catch the instructions of Mr. Prasad.
I don't
Catch
know.
him with the instructions or without the
I
instructions.
have just caught him. He's going to come and indicate what he's come with. This will not. So far, the earlier
Records have not yet been traced out.
No, his records will not be traced out. Kindly set it aside. I'll cite two Supreme Court decisions. আবার এক বছর রেকর্ড পাওনি
On the basis of I can show your lordship lord the order which I did pass 7A lord. That is quite lord the dismissal order lord with reasons your lordship can consider.
All right.
Lord, they have also filed review against that 7A order where they have lost. So lord, I have to place that because lord that list of members that were submitted by
I'll address
on the
it.
basis of that inquiry of
I'll address it.
Concerned-
All right, let me.
Look,
When I joined the profession, I used to be extremely scared of Mr. Prasad because every matter he used to argue with such aggression, and he would not let anybody speak. I used to stand behind him and worry that hoping he would not be on my other side. He has not changed even today. I have lost hair, spent 20 years here. He has not changed.
Yes.
He does not address your lordship why the court wanted him to bring the documents. Well, there's an order which I had last also shown. The court considered something and asked him to bring the documents because it was the finding. Which order? You know, that order.
30th of November.
Yes. 30th of November. May I just place it? Learned advocate appearing for the petitioners draws the attention of the court to an order passed under Section 7A of the Act, determining the dues on period November 1995 till 31st of January 2004, and submits that by the order dated 7th October, the Assistant Provident Fund Commissioner observed that the amount was due from the establishment under the scheme towards principal dues has been paid by the establishment different dates. He further submits, disregards all this. The submissions are noted. Second page 2, third paragraph.
Yes.
Mr. Prasad, learned advocate appearing for the Provident Fund Authority, submits that this is a writ petition of 2006 and therefore he requires some time to consult the records of the case to apprise this court as to the basis of the determination under 7A of the Act, which culminated in the order dated 23rd.
So there is an overlapping period.
There is your lordship remembers.
Not overlapping.
For some period,
the equation of membership.
the earlier order says there is no due. Subsequent order takes care of a portion of that period.
Portion
and
of that
says
order of employees who are not even why please.
Yes.
For that, one bit is the overlapping. Second, there is no determination, and I'll show that there is no determination as to the employees or contractors who have got or have not got, or how they were entitled and how the commissioner came to the determination under 7A. Lord, simpliciter by giving a list. Your lordship from 1990 have held that just by relying on a list, you can't attract this kind of liability. Because then you are in dereliction of a statutory duty, which requires you to determine. And your lordships have consistently again held that word determine means that you apply yourself to the evidence that is there. In every
arrive at a conclusion.
You have to arrive at the conclusion. And in every matter your lordship will come across, Provident Fund comes and says, we don't have evidence. We've relied on what the establishment has come up with. That also again your lordships have very heavily come down upon, saying this is not the test. You can't pass the buck on to an establishment. But here what they've done, I'll just indicate.
Where is the order? Initial order?
Lord,
thereafter there was a review.
Yes, review. I have never come across anybody who's won in the review. No, but 42, your lordship will see.
Yes.
Page 42 is the impugned order.
Page 42.
42.
That is the initial order.
This is the 7A order. 23rd June 2006. Matter under 7A of Provident Fund, where an inquiry under 7A of the Act has been initiated by a 7A summons dated 27 January 2006, fixing the date of hearing on so and so in order to assess the dues against evasion or non-enrollment of employees. Lord, please mark these two words, non-enrollment of employees, to the scheme. Thereafter, the hearing is taken up on different dates, and finally, and whereas finance control obj so and so appears, and whereas the representative of the management submit that PF membership was extended to all the employees, including the casual contract employees, and the PF amount was deposited to the PF trust, but the pension fund membership could not be extended to certain employees.
and both the share of 12% of PF were credited in member's PF account lying with the trust and settled to the member who applied for it on retirement or separation from the establishment, and pension fund contribution at 8.33% in respect of existing employee not enrolled to pension fund, and those who have been retired or separated from the establishment did not withdraw the PF accumulation are being paid or remitted to account. Number X of statutory fund maintained by the Regional Provident Fund Commissioner. The management submits that it may not be insisted to pay pension fund contribution in respect of all such employees who already got settlement of PF accumulation, and in such cases the individual member refunds the pension fund contribution with up-to-date interest. The management will remit the same and forward necessary returns and claim. If I may just pause here for a moment, why this happened? Because earlier there was that pension scheme, your lordship recalls, which there was a dispute with regard to what will be the extent of pension scheme. If there is a provident fund, where what is more beneficial, what will come up, finally get settled by a Supreme Court decision. In the interregnum, a lot of some employees retired, they had taken their pension fund contribution and gone. Some came back and took their provident funds. So those are the ones that are identified here, saying those we've paid. Keeping this in mind, I'll take your lordship back to the first order that was there. The Provident Fund authorities find that to be correct because they find that nothing is due and payable. Then the inquiry begins at page 42.
Page 42?
Yes. The last paragraph. Yes. Departmental representative submits the deposition in form of EO's report dated 9/6/2006, furnishing the dues position against the employee's pension scheme account for the period April 2002 to May 2005 against non-enrollment of employees to the pension fund. All such employees who are not enrolled to pension funds, Sri A. Shah submits that the employer is legally duty bound to extend pension fund membership under EPS 95 to all such employees who join the PF scheme either in the exempted establishment under approved PF scheme or under statutory EPF scheme. He also submits that as evident on perusal of the report of EO dated so-and-so, the establishment is paying pension fund contributions since June 2005 onwards in respect of all the employees. On perusal of submission of the employer in the department and after applying my mind to the evidence on record, it is evident that the employer failed to extend membership under EPS 95 to certain employees varying from 126 for the month of April 2002 to 151 for the month of May 2005 and did not pay pension fund contribution to the statutory fund account number X, which is not acceptable as per the provisions of the Act and scheme so-and-so. Hence, on the basis of evidence available on record, I determine an amount of rupees so-and-so that is payable, and he imposes a penalty of also approximately 15 lakh. So what does he do? He relies on the inquiry officer's report. Inquiry officer's report apparently has 126 for month April 2002 to 151 for the month of May 2005. Now this, now your lordship,
3 years, more 1 month.
That 1 month more. Now kindly comes to page 29.
Where is the inquiry officer's report?
He will give. He will give. Where is the list? How does he make these determinations?
My lord, so far the
I thought you take your seat. You get your chance. Yes.
Page 29. This is an order under 7A dated 7th of October 2004.
Yes.
Period, your lordship will find. I'll just place the last 2 lines.
Give me a minute.
Sorry, the last from 3 line onwards for determination of dues for the period of 16 November 1995 on page 29. Sorry, my lord.
29, yes.
Page 29 at the top.
Yes.
The instant inquiry has been conducted against Woodlands for determination of dues, for the period from 16 November 1995 onwards under the employee pension scheme, EPF so-and-so. Inquiries initiated separately for different periods for the purpose of determination and EPS dues have been clubbed together and extended up to 31st of January 2004.
So this is from 16/11/95
till 31st January 2004.
31/1/2004. Yes.
In view of the fact that the establishment has started regular compliance under EPS 95 with effect from February 2004. Pursuant to summons dated disregards who appeared, they have submitted the following documents. All these documents are submitted in 2004. The authorized representative submits that the establishment has cleared the entire arrear towards pension fund along with interest. Hence, the matter may be closed. I have verified the documents submitted by the establishment, especially the certificate given by so-and-so. I find that rupees X was due from the establishment under the scheme towards principal dues which has been paid by the establishment. Hence, the matter is closed. It is clarified that the establishment is also required to transfer the cumulative interest that he's got from this to this period. So, from 95 to January 2004, everything is clear. Here, somehow, Mr. Ashraf Kamil finds that from April 2002, I have not extended this to 126 people. Then again 151 from 2002 to May 2005, Your Lordship will compare it at page 43. There is no basis. There is a list.
So
and that
4 months there may be something.
So this is the point. When
Whether
Your Lordship,
for this 4 months.
Correct. That's the only issue. With this same discussion we had, he got up and said, I'll get record. This was Your Lordship's query, that how if there is, and this is not my order, respondent can't challenge their own order in petition. This is his own case that till February 2004. Now this distinction that Mr. Kamil makes here of 126 from April 2002 and 151 for May 2005, there has to be a basis. Please disregard this English that I'm talking in court. One judgment, Your Lordship will allow me to cite. This is reported in 1990, Volume 1, Supreme Court Cases, 68. I have to copy it. This is not determination under 7A.
Yes. Paragraph?
Yes. Lord, paragraph 6 onwards, if Your Lordship kindly has a look at. We have carefully perused the Commissioner's order. There, the stand of FCI in this judgment is identical to the stand of Woodlands here. Because my case has been that when you first, my lord, I'll indicate, Your Lordship would recall that I have made paper publications also. That people who have gone want to come back and take. People who have not taken and want to refund, please come. Nobody's come forward. They identify a list, and that list they have some assessment which is on the basis of an inquiry report which at least to us and to the court has not seen the light of the day. Then this assessment is now being questioned, and what is the test in law? We have carefully perused the Commissioner's order and also the order of the High Court. The total amount ordered to be payable comes to about 22 or 48 in respect of employees of depots, namely so and so. The Commissioner has also directed the Divisional Officer Jaipur to deposit the funds. It is indeed a large amount for the determination of which the Commissioner has only depended upon the list furnished by the Workers' Union. It is no doubt true that the employer and contractors are both liable to maintain registers in respect of the workers employed. But the corporation seems to have some problems in collating the list of all workers engaged in depots scattered at different places. It has requested the Commissioner to summon the contractor to produce the respective list of workers engaged by them. Here, I have gone and given a publication, advertisement. The Commissioner did not summon, please mark this, Milord. The Commissioner did not summon the contractors nor the lists maintained by them. He has stated that the corporation has failed to produce the evidence. The question, in our opinion, is not whether one has failed to produce evidence. The question is whether the Commissioner, who is the statutory authority, has exercised powers vested in him to collect the relevant evidence before determining the amount payable under the said Act. It is of importance to remember that the Commissioner, while conducting an inquiry under 7A, has the powers as are vested in a court under the CPC, trying a suit, and then the determination is set out where I can enforce attendance, issue summons, that bit. 9 again, may I, my lord? It will be seen from the above provision that the commissioner is authorized to enforce attendance in person and also to examine any person on oath. He has the power requiring the discovery and production of documents. This power was given to the commissioner to decide not abstract questions of law, but only to determine actual concrete differences in payment of contribution and other dues by identifying the workman. It is not a nebulous entity. The commissioner should exercise all his power to collect all evidence and collate all material before coming to a proper conclusion. That is the legal duty of the commissioner. It would be failure to exercise the jurisdiction, particularly when a party to the proceedings requests for summoning evidence from a particular person. My categoric stand was, beyond this, I can't help you with any further evidence. These people have gone. There is no further documents I have. Now, this distinction, Your Lordship, has seen at paragraph page 43, where a period where under 7A I was found to have complied with. Then he makes two separate lists, 126 for the month of April 2002 and 151 for the month of May 2005. Disregards the 7A order. This conduit between 126 to 151, where does he get this from? Disregards the 7A order. At least this he will identify. What is the solitary document that they have? I'll show that. The only thing that they have is at page 40. 40. Sorry, Mullah, I'm sorry. 40 is the last page. It starts at page 35. 30. Sorry.
What is this document?
31 it starts.
What is this document?
Well, this is 31. It says total pension of casual staff, which has been paid to them at the time of the settlement.
Who has provided this?
But they found this from us. And this has been
produced.
Yes, yes. This is my stand. That all this we paid off. There is no, and date-wise, contribution-wise,
so this is a list of how many persons?
This is a list, my lord.
Because the number is,
yes, at the end.
Number. Oh, 691, 7.
If your lordship turns over to page 40, kindly turns over to page 40.
40, the number is not legible. What is the amount?
There is a handwritten noting, if your lordship finds. 40 at the left-hand bottom.
284.
Yes, 236 settlement taken, 48 pension deposited.
Yes.
Now this chart is what we also have. We also gave them. Now let them show on what basis they arrived at the 7A finding. Because my
126 and 151.
126, 151. When their own 7A based on this chart. And not just that, one more thing your lordship will just see.
Yes.
At page 23. This is 15th of February 2006. Sorry.
23.
Page 23, left hand top. Your lordship will find the date.
16th February 2006.
2006. At the top left hand corner. Kindly have, we've taken the liberty of marking it. There's a public notice with about 4 black brackets.
Yes, yes.
Public notice, Woodlands Hospital, that is me, petitioner. This is to intimate that all ex-casual employees who have not withdrawn their PF dues are requested to collect the same within 15 days from our office from the date of publication of this notice.
Whoever have come, you have settled.
And the rest is deposited and disregards what I have said. That's their own 7A determination. And then firstly, how does he for that same period identify 126 people? Then he finds 151 for a very abstract period because he doesn't say 2002 to 2005. So that remaining 31 also, where do they get those people from? Who has come to the commissioner? Or what record? Now, if your lordship tests it on the anvil that's in the Supreme Court judgment, where there is no determination.
Yes. Anything more?
Nothing more.
Yes, Mr. Prasad.
There is one more judgment that my junior Mohammed I should cite, but it's identical on this principle. But I'll still show it and all. যেটা ওই তো এখন পড়ালে যেটা স্যাটিসফাইড করে বললো পুরোটাকে আবার করে করতে, এইটা না? হ্যাঁ, 2008 5 Supreme Court cases 786 দিয়ে দিচ্ছি তোমাকে, ঝগড়া করো না।
Yes, paragraph
5, just last 4 lines.
Yes.
Last 4 lines, my lord. We accordingly dismiss the appeals, but reiterate the recommendation that the amount due from the corporation will be determined only with respect to those employees who are identifiable and whose entitlement can be proved on the evidence, and in that event the record is not available with the corporation, it would not be obliged to explain its loss. So it can't be a nebulous character. It has to be people against whom I should have made the deposit. I have not made. That determination is done under 7A. Now, one interesting fact. After this order that your lordship has seen of November, he said, I have to go get records. Then what happens? The Provident Fund authorities write a letter to Woodlands saying, pursuant to this order, you give us records, whatever records you have. I suspect, it could be wrong, that Mr. Prasad's office has no records left of this. This is the letter after your lordship's order from PF India, EPF India. In compliance with the directions, it is requested to forward the detailed statements chart in respect of all 126 employees with supporting documents for the period from April 2002 to May 2005, the amount assessed under so and so final order.
Yes, Mr. Prasad.
Yes, my lord, pursuant to lordship direction, my lord, we have tested out the record, but we have not located all those records, but it's a very old record, my lord, of 2004, my lord, and today we are in 2024, my lord, past 20 years, my lord, we have not, but my lord, even then, my lord, we have written to them, my lord, because, my lord, we have prepared the report. The report was prepared on the basis of the documents.
Where is that report?
The enforcement officer's report, my lord, I'm saying.
Where is that?
The report must be, my lord, in the file. If your lordship wants, my lord, report, my lord,
Did you give them the copies of the report?
at the time when
Yes,
when
yes.
the application, my lord, I do not know whether they have asked for it. my lord.
Show me from the order that this was supplied to them,
Page,
they were given an
my lord,
opportunity, and how have you dealt with that?
my lord, then your lordship kindly comes to the, my lord, summons, my lord, page 23, page 24, annex P3.
Yes, page 24.
Yes, my lord, here, my lordship kindly says, my lord, because before the issuance of that order.
This is summons to the Woodlands.
Woodlands. My lord,
They have
what-
given the,
my lord, we have already said, my lord, what documents.
they have produced these documents.
Yes, my lord, what we have, my lord, asked for.
Yes.
Kindly takes, my lord, page, my lord, now therefore, my lord, page 24. Now therefore, in exercise of powers conferred on me under section 7 of the Employees Provident Funds and Miscellaneous Provisions Act 1952, he was hereby summoned to appear before the undersigned on 22nd February 2006 at 3 p.m. in the office of the second not in person or to an authorized, duly authorized with relevant records mentioned below for conducting inquiry and determining the amount due from your.
So they have produced these documents.
Yes, my lord,
Please have a look at 6. I'm sorry,
Yes,
6 serial
my lord.
number 6.
Attendance register.
At page 24.
Cash book, my lord, payment register.
6 টা পড়ো না।
পড়ছি তো। Why are you forcing me?
Yes.
The details of all the contractors and contract employees.
So they have complied with this.
Must have been, my lord, then the order. had to-
How have you dealt with this?
My lord, then, my lord, your lordship, my lord, wants, my lord, the report.
No. You show me from the order.
From
I
the
don't
order,
want the
then your
report
lordship can-
because you have nothing in your office. Or you cannot trace out anything from your office.
My lord, the question is, my lord, your lordship.
Mr. Prasad, you cannot improve upon
No,
the
no,
order.
my lord,
You have to
my lord, I'm just
stand or
in my
fall
own way, my
on
lord,
this order itself.
In my own way, I want to convince your lordship.
Yes, in your own way.
My lord, lordship, can you see there are two things.
Don't be swayed with the observations of Mr. Banerjee, which he made at the beginning.
No. Yes.
Yes. You can proceed in your own way.
Own way, yes. Lordship can see that there can be two ways. At the time of passing the order, report must have been served to them. If they have not, my lord, they could have, my lord, asked this, my lord, that kindly supply me the copy of the report. Your lordship would not find, my lord, I'm going through the order. Your lordship would find, my lord, that whether they have asked for it or they even after asking, it has not been supplied to or furnished to them.
All right, let us for the present accept that
yes, my lord, that
inquiry
aspect,
report
my lord,
was served
that
upon them.
aspect cannot be questioned today, my lord, because they have not, either they have asked it.
How have you dealt with that?
Yes, my lord.
Show me from the order.
Page 42, my lord.
Yes, page 42.
Page 42. That, my lord, paragraph 3. And whereas the representatives of the management submit that the PF membership was extended to all their employees, including the casual contracted employees, and the PF amount was deposited to the PF trust, but the pension fund membership could not be extended to certain employees, and both the
Mr. Prasad, you can skip this because these are the two respective submissions of the yes. You can skip that.
There was only dispute with regard to the extension of membership to some of the employees which have been
Kindly come to the next page on perusal.
on perusal. Yes. Now, my lord, on perusal of submission of the employer and their department, and after applying my mind to the evidences of record, it is evident that the employer failed to extend membership under EPS 95 to certain employees varying from 126 for the month of 2002 to 151 for the month of May 2005, and did not pay pension fund. So these are the employees to whom extension of
So is it a speaking order, Mr. Prasad? I am asking you. One line order after hearing. Let us also, if an order is passed by this court, after hearing Mr. Banerjee and Mr. Prasad, and after considering on the materials on record, I find this. What will be your first ground in the appeal? I'm asking you.
ছেড়ে দাও, একটা মামলায় বলতে পারো যে আমি এটা কিছু নেই।
My lord, one respect to should have been one respect to submission, my lord. Now the matter is, my lord, because your lordship is asking, my lord, about the report and all that. My lord, my lord, one day I want, my lord, for report or if
no report.
Or
Mr. Prasad, even if you bring the report, consideration of the report is not here.
Yes, then
so you consider the report and take a decision.
Then, my lord, my respectful submission, my lord, after perusing and after hearing, my lord, the lordship can kindly remand the matter back to the authority concerned. For this, my lord, because my lord, because
May I just make one prayer, my lord? Kindly do not remand it. Set this aside. If they want to initiate, let them do that, because I know why he's doing this, because they're writing letters to me. Now they'll say that you come and produce anything again. No. From 95, I will not have these records.
If my learned friend says so.
Mr. Banerjee, a proceeding was there that was initiated.
Yes, so if they want
it is set aside,
they'll be at liberty to take steps.
Yes, they will take steps.
Yes, yes. That of course, that much they
also cooperate
you
with
must be having the documents. What documents you have, we will produce.
Yes,
that.
yes. That they can do so in accordance with.
Cooperate with the adjudicating authority, my lord, while asking, my lord, all those documents. When they will, my lord, just like, my lord,
Yes.
the lord seen the summons, we have asked for certain
Mr.
documents.
Prasad, he will say report was not served upon me.
He
And
cannot,
you also,
my lord, after getting some report,
you have any documents to
must, my
show
lord,
that report was
acknowledge the- Yes.
Mr. Prasad, if you have any documents to show that the report was supplied to him,
Use it.
show him.
Use it.
Yes, I have supplied to him.
Kindly, my lord, ask, yes.
Remand, no, set aside. With liberty to proceed afresh. তোমার কাছে কিছু নেই, হ্যাঁ? আর কেউ আসবে না।
The order of the Assistant Provident Fund Commissioner, Regional Office, Kolkata, dated June 23, 2006, and the order passed in connection with an inquiry under section 7A capital A of the Employees Provident Funds and Miscellaneous Provisions Act 1952 and the order of the state authority dated July 19, 2006 on a review application filed under Section 7 capital B of the 1952 Act is under challenge in this writ petition at the instance of Messrs. Woodland Medical Center Limited. First. Paragraph. Mr. Banerjee, learned advocate appearing for the petitioner, submits that the order dated 23rd June 2006 is a non-speaking order. He further submits that the tests laid down by the Honorable Supreme Court in the case of Food Corporation of India versus Provident Fund Commissioner and others, reported at 1991 SCC, Volume 1, SCC 68, was not complied with by the Assistant Provident Fund Commissioner while passing the impugned orders. First up, he further submits that the Assistant Provident Fund Commissioner, by an order dated October 7, 2004, held that there is no amount due and payable from the writ petitioner for the period from 16th November 1995 to 31st of January 2014. কি বলে শুরু করলাম? He further submits that but in the subsequent order dated 23rd of June 2006, it has been held that a sum of rupees 19,97,089 is payable by the establishment for the period from April 2002 to May 2005. First up, paragraph. Mr. Prasad, learned advocate appearing for the Provident Fund Authority, submits that the Assistant Provident Fund Commissioner, after considering the materials available on record, determined the amount payable by the establishment. First up, he further submits that the state authority also assigned cogent reasons while dismissing the review application filed by the writ petitioner. First up, heard the learned advocates for the parties and perused the materials placed. It appears from the record that an inquiry was conducted against the writ petitioner establishment for determination of dues for the period from 16/11/1995 onwards under the Employees Pension Scheme 1995, framed under the 1952 Act. Inquiries were initiated separately for different periods for the purpose of determination of the dues, and it was observed in the said order that the establishment started regular compliance under the under the 1995 Act with effect under EPS 1995 with effect from 1995 Act under EPS 1995 with effect from February 2004. So the said order further records that the establishment has cleared the entire area towards pension fund along with interest. Full stop. Paragraph. However, from the order dated 23rd June 2006, it appears that an inquiry under Section 7A was initiated for assessing the dues against evasion/non-enrollment of employees to the EPS 1995. After going through the said order, this court finds that the authority held that the employer failed to extend membership under EPS 95 to certain employees, varying for 126 for the month April 2002 to 151 for the month, varying from 126 for the month April 2002 to 151 for the month of May 2005. So the said order records that an inquiry was held, but how the report of such inquiry was considered has not been indicated in the said order. That apart, when the authorities, after verifying the records, arrived at a finding that there is no dues from the writ petitioner establishment for the period November 16, 1995 to January 31, 2014. The basis of arriving at a figure that an amount is due from the writ petitioner establishment for the period from April 2002 to May 2005 has not been explained in the order dated 23rd of June 2006. First up, the said order only records that on perusal of submission of the employer and the department, and after applying the mind to the evidences on record, it is evident that the employer failed to extend membership under EPS 95 to certain employees. From the said order, this court fails to find as to how the evidences on record were appreciated by the said authority. First up, since the order is an unreasoned and non-speaking order, the same is liable to be set aside and quashed for such reason alone. Full stop. By the order dated July 19, 2006, the Assistant Provident Fund Commissioner rejected the application for review. The said order also did not take into fact that did not also did not take note of the fact that the original order was passed without assigning any reasons. First up, for such reasons, the impugned order are set aside and quashed. First up, the authorities shall proceed. The authorities will be at liberty to proceed in accordance with law after giving an opportunity of hearing to the petitioner and any other interested parties, and to pass a reasoned order in accordance with law. First up, তার আগে একটুখানি একটা প্যারাগ্রাফে লিখে দিন।
But may I pray for one indulgence that if they decide to undertake this exercise, they'll do so in accordance with the 1990 judgment that your lordship will kindly provide. Otherwise,
in accordance with law, I've said that has to be in accordance with the judgment. There is no quarrel to the proposition. না, তার আগে একটুখানি লিখুন। The Honorable Supreme Court in Food Corporation of India Supra has held that the power is given to the commissioner under the 1952 Act to determine actual concrete differences in payment of contribution and other dues by identifying the concrete differences in payment of contribution and other dues by identifying the workman. It was further observed therein that the commissioner should exercise all his powers to collect all evidence and collate all materials before coming to proper conclusion. First up, in the case on hand, the Provident Fund Commissioner has passed the order dated 23rd June 2006 without determining the without identifying the workmen in respect of whom there may be dues from the writ petitioner establishment.
Very great.
So, for such reason, this court is inclined to.
Very great. The only thing, my lord, we had deposited a sum of 10 lakhs on 25th of September 2006 for the purpose of the interim order. With this, now that money be given back to us in this court.
That would be
if that has been set aside,
that
was as a condition.
That would be abide by the result, my lord, of the.
No.
Lordship, can you give some time?
You initiate,
no.
Then they will approach.
Then I will deposit again. From 2000,
by which order?
25th September 2006. I can hand it over, my lord. It is Achhoka Didina, please. Lord pardons the condition it is in.
25th September, yes, I've got that.
My lord, my submission, my lord, that lordship can you give a
Hey, why?
Time bound, lord.
He can't produce any record time.
At liberty, you do within a week, he will approach immediately thereafter, and you will get back now 20 lakhs, not 10 lakhs. After this order was passed, Mr. Banerjee, learned advocate appearing for the petitioner, draws the attention of the court to the order dated 25th of September 2006, wherein the petitioner establishment was directed to deposit the amount of 10 lakhs.
No, Provident Fund authorities.
As a condition for grant of an interim order. First up, after going to the said order, this court finds that such payment after going to the said order, this court finds that it was recorded in the said order that such payment shall be without prejudice to the rights and contentions of the parties and will be subject to the result of the writ petition. First up, since this court has set aside the impugned orders, the Provident Fund authorities are directed to refund the said amount to the writ petitioners within a period of
4 weeks. No.
With Provident Fund authority will take 4 weeks.
My lord, 2 weeks, my lord, he'll otherwise start that entire thing churning again. Please give this for.
Within 3 weeks, my lord, we will try to.
All right, 3 weeks. 3 weeks from date.
From the date of communication.
Or 2 weeks from
From the
receipt of the server copy. Choice is yours.
From the date of communication of the.
Then 2 weeks.
3 weeks. 3 weeks, my lord.
From the date of receipt. 3 weeks from the date of receipt.
Along with the accrued interest thereon.
Yes, together with accrued interest thereon.
Very great.
Yes, call the next matter.
Very great.
79.
Yes, CSC has challenged. Rarest of rare case. Mr. Rai, this is the rarest of rare case where CSC is challenging
No, my
the
lord.
consumer approaches.
Yes, usually it does. My lord, here,
Most
my
of
lord-
the case.
Yes. Lord,
Yes.
a peculiar
Who is
case,
appealing
my
for
lord.
the other side?
Mr. Kole will be for the.
So according
appellate
to you, the
authority.
other side's presence may not be necessary. The merits is such.
My lord, it is meritorious. There is no doubt about it. But my lord, I do not know.
Who is appealing? Raja
Kole
Shah,
will-
Bishop, no, they are for the state.
Kole will appear for the appellate.
Respondent number 3, Vidyut Haldar. Yes, let me hear you. If I find something, then otherwise.
Yes, your lordship will find that I'm sure.
Yes.
No, my lord, here, my lord, the final order of assessment was passed on the ground, my lord, of abstraction of electricity through a tampered meter. My lord, the consumer, my lord, challenged the order passed under section 126 in appeal before the appellate authority. My lord, the appellate authority upholds CSC's contention that there was tampering of meter and that, my lord, abstraction of electricity has been done through unauthorized means. But my lord, the
So
appellate
provisional assessment confirmed.
final assessment
Confirmed.
assessment has not been confirmed. The finding of, my lord, unauthorized user of electricity has been confirmed. Calculation, my lord, has been tampered with, my lord, absolutely illegally. Why I say this, my lord, your lordship will kindly
So
take.
appellate authority has reduced the figure.
Asked me to reduce it, my lord, following a different, my lord, calculation.
What is the difference, Mr.
My lord, the difference is, my lord, the difference is in the policy. Why I say so, my lord. Otherwise, my lord, the amount is not very high.
So
My lord,
according to you, this decision will affect your
yes. Now, my lord, if your lordship
in
sees,
future matters.
yes.
Yes, that's the content.
You are for
That is the content, sir. I am for the appellate authority.
for the appellate authority.
I have not. I have
So
nothing
you are
to
for
say.
the appellate authority.
As your lordship will decide, me not. I have bowed down to your lordship. Me not. I have.
Yes.
Your lordship will kindly take, my lord, page 50. Page 50 is the final order of assessment. I shall just show your lordship, my lord, the part of the calculation and take your lordship to the appellate authority.
Authority has to be made a party, Mr. Rai.
My lord, since it is an administrative authority, my lord, they are not judicial authorities. Therefore, my lord, we make. Lord, if it was a judicial authority, my lord, we could not have.
Yes.
Lord, kindly take, my lord, page 54.
Yes.
Page 54, my lord, your lordship will find there is something written in bold as assessed units. My lord, just after the first two paragraphs at page 54, assessed units.
Yes,
Assessed units. My lord, your lordship will find there is a figure 8.50 kilowatt into 0.80, which is, my lord, the load factor into 365 days into 10 hours. Now, my lord, why this is coming, your lordship will kindly take, my lord, the regulations, which were then, my lord, in vogue.
This is the order of the appellate authority.
No, my lord, this is
No,
the
this
order.
is the assessing of.
Assessing officer. My lord, I am taking, your lordship, my lord, step by step. My lord will kindly take, my lord, page 13 of the regulations. Page 13.
Yes.
Lord, your lordship will take, Lord, 5.0. Assessment of electricity
Yes,
charges
yes.
payable under 126. Now, my lord, the formula is provisional assessment under subsection 1 of section 126 shall be made as per the following method, which is P is equal to A plus B minus C. Now, my lord, P is the charges payable by the person for unauthorized use of electricity. How it is to be found? A is total connected load in kilowatt at the time of inspection or the contract load in kilowatt, whichever is higher. My lord, that your lordship will kindly, my lord, keep it side by side. Kindly take page 54. My lord,
That is 8.50.
8.5. Load factor, my lord, this is 0.80, my lord, which has been written as DP. My lord, that is the connotation. This is the load factor. Next, my lord,
Period is 365 days.
Yes, 365 days, my lord, because unascertainable period, and 10 hours, my lord, because this is a factory which we have found to be working for 10 hours. So 365 days into 10 hours, my lord, which is the period in
Why
hours.
365?
My lord, 1 year, if I am not being able, if lordship takes, my lord, page 126. So section 126.
Electricity Act আছে?
Ache, lordship. I am handing up to your lordship. Lord, kindly take note 126.5.
For 12 months.
Yes, 12 months, my lord, means 365 days. My lord, it has to be in hours. Therefore, 365 into 24 would have been the calculation. We have found 10, so we have put 10. Now, my lord, kindly take the appellate authorities order. Lord, it begins at page 99.
Yes.
99, Lord. In the context of an inspection of the meter and metering installations of the appellant on
where is the calculation made here?
Yes, my lord. If your lordship sees the calculation, lordship, page 100.
Yes.
My lord, kindly see the last part.
Yes.
The final order of assessment dated 5508 is therefore set aside with the stipulation to regenerate the bill, taking into consideration connected load 8.5 kilowatt.
That is okay.
Number of days 240 instead of 365, and running hours 6 instead of 10 hours. My lord,
so what is the reasoning given?
Yes, I'm grateful to your lordship. That is
no reasoning.
No reasoning. Kindly have a look, my lord, at page 99. I'm taking your lordship just, my lord, to the contentions. Page 99, third paragraph. Third paragraph.
Yes, this is your submission.
This is the submission of the appellant there. That is,
yes.
That is the consumer.
Yes.
Now, my lord, kindly take the last paragraph is our submission. That is CSC's submission, representative of CSC.
Yes.
Both parties submitted documents. On examination of the documents and submission made, it appears that there has been an unauthorized abstraction of.
No. The reasoning might be, Mr. Rai, 100. The first paragraph, first continuing paragraph is the consumer at the time of hearing.
Very well, my lord. I'm reading.
I think only
yes.
for that might
yes.
be the.
Very well. The assessing officer, before issuing final order of assessment, visited.
No. Page 100, first paragraph continuing.
Consumer was running a factory.
Consumer at the time of hearing. Fourth or fifth line from the top of that paragraph.
The consumer. The
Yes.
consumer at the time of hearing before issuing final order of assessment submitted that the factory operates for 20 days a month and 6 hours per day, and the connected load of the LS tamper meter was 12 kilowatt. Having considered the consumption pattern and the connected load, the tampering of the meter was clearly evident, and consequently the tampered meter was not sent for testing to an independent authority. Lord, this is our submission. Thereafter, both the parties.
Your submission.
Yes, it is continuation of my submission, Lord, the representative of
CSC Limited.
Yes. Thereafter, both the parties submitted documents. CSC Limited also submitted number of photographs taken by the assessing officer. On examination of the documents and submission made, it appears that there has been unauthorized abstraction of power, for which the consumer is liable to pay assessment bill under section 126 as amended up to date. Final order of assessment was not made as per provision of regulation. Lord, I do not understand how this conclusion is arrived at.
One thing.
Yes.
Mr. Rai, this was your submission.
Yes.
That this factory operates for 20 days a month and for 6 hours per day. This was your submission.
No, it was not my submission.
Yes,
Lord- if Lordship
representative of CSC.
Yes.
You said that. I thought that it was for the consumer. But it
The
said that
consumer, it is our submission that the consumer submitted this. Kindly read that, my lord. The consumer at the time of hearing, before issuing final order of assessment, submitted. If your lordship takes that line 1, 2, 3, 4, 5, fifth line from the top at page 100, the consumer at the time of hearing, before issuing final order of assessment, submitted. That is, the consumer submitted that the factory operates for 20 days a month and 6 hours per day, and the connected load of the alleged tampered meter was 12 kilowatt. This was what the consumer submitted to us before issuing
All
the
right.
final order of assessment.
Mr. Rai, is it your submission that the factory operates for 30 days a month?
My submission is that it operates for
Have
10.
you produced any documents that
My
it
lord-
runs 30 days a month?
Lord, it was
because
for
this is the submission of the consumer. It runs for 20 days a month. You have not disputed that.
No, my lord,
There is
I have
nothing
said,
to show.
I have said that it runs for 10 hours per day.
Yes.
And my lord,
But
if-
how many days in a month? You have not said
if,
that.
if the period is unascertainable, then it has
I
to
will
be 12
come to
months.
that.
Yes.
Mr. Rai, I will come to that.
Yes.
You have not disputed that the assessee's case is, or the consumer's case is that it runs 20 days a month. You have not disputed that.
No, my lord, we have not accepted this. We have
You
not,
have not disputed
My
this
lord, this
also.
is the assessing officer, this is the appellate authority's recording. My lord, if you
Yes, no. Mr. Rai, you have said representative of CSC Limited submitted that at the time of hearing, consumer submitted.
Yes, my lord, that your lordship will find in my final order of assessment. Kindly take my final order of assessment then.
Yes.
Kindly take, my lord, page 51. Page 50 it starts.
Page 51.
Page 50 it starts at page 50. Final order of assessment starts at page 50.
Yes.
Kindly take, my lord, page 51.
Page 51. Show me only that with how many hours in a day. I'm only interested in that.
Page 51, my lord.
51, yes.
Other information gathered from the aforesaid report of engineer. Days of operation. The days of operation is taken
I
as,
could not get 51.
my lord, the at the top. Other information.
Other information.
Yes. Now, my lord, nature of use, then load, then days of operation.
Aforesaid report of engineer.
Report of engineer, my lord, the engineer who visited.
Sir, right. Factory does not operate for 30
My
days
lord,
a month.
it may not. It may not, my lord. I have to reach to a conclusion, my lord. If I cannot reach to
I
a
will
conclusion.
come to that.
Yes.
So these days, 30 days, because they have, their case is that, consumer's case is that it runs for 20 days a month. You have not produced any document
Lord,
to counter that.
They have to produce documents to show that it does not run for 20 for the entirety of the period. If, my lord, they cannot produce it, my lord, I have to take it as 12 months.
Yes.
All the
12 months is one thing, and 365 days is a different.
12 months, my lord.
Because the statute does not say 365
Lord,
days.
statute says, my lord, 12 months.
12
and regulation, my lord, says 12 months converted into hours. Kindly take the regulation.
Yes, 12 months converted into hours.
12 months.
Not 12 months into days into hours.
But if 12 months is converted into hours, the only
There
way
will
is
be
to
a difference, Mr.
My lord, if 12 months
maybe 12 months means in a 1 year. So what is the logic? The abstraction will be during the period for which the factory runs. It could not, because we have taken 10 years.
Correct.
10 hours.
Yes.
Not 20 hours,
No,
not
I have
16
not taken.
hours.
I could have been justified even in
You have
taking
not
24
taken.
hours.
So you are reasonable in that. I'm
Yes.
not saying that.
Yes.
So you are reasonable in that. You have not accepted 24 hours.
No.
So you have taken 10 hours, meaning that the factory will run for, or you have documents to show that 10 hours. So now, whether it will boil down to the fact whether it runs 30 days a month, 20 days a month, or 10 days a month.
My lord, now it was therefore, my lord,
because that will differ. That is the order of the appellate authority. Appellate authority, Mr. Rai, has gone to
say that it is
Yes.
Appellate authority says 240 days.
Yes, 240 days taking
20
20 days
a month.
in a month,
My lord,
12 months.
Therefore, he accepts.
Statute says 12 months.
Yes, my lord. I also say, my lord, 30 days, my lord, 365 days, 12 months, my lord, will be valid.
Mr. Rai, where is the evidence to show that it
My lord,
is
that evidence, my lord,
30 days?
my lord, your
I
lordship will
think
kindly.
there has to be under the Factories Act. There is something you cannot run for the entire 30
My lord,
days.
that would be, my lord, if it is operating legally. Now, my lord, here,
Mr. Rai, your case is not that it is operating.
my lord, my case is unauthorized abstraction of electricity. My lord, it is a tannery. It is a tannery.
Unauthorized abstraction is one thing.
For running a tannery. For running a tannery
Yes,
here.
but the allegation is not that it is running in violation of the Factories Act.
My lord,
One
no,
thing
not
is,
violation of Factories
yes,
Act. I have not
so
proved it.
Factories Act, if the authority, appellate authority, is the last authority on facts, if it has accepted on these working hours, why the writ court will interfere on that?
Kindly take, my lord, page 50.
Because on facts it has held.
Kindly take page
I
50.
cannot reopen that.
My lord, kindly take page 51, my lord. I am absolutely, my lord, at one with your lordship on this. My lord,
51.
kindly take page 51.
51.
Page 50.
50. Yes.
My lord, kindly take paragraph 2. Why I say, my lord, illegal? While attending to an off-supply complaint from the above
Page
tenant.
50, paragraph
2. My lord, this is
Yes.
the assessing
While
officer's
attending.
While attending to an off-supply complaint from the above tannery premises.
Yes.
My lord, it is such a tannery premises, my lord, which was supposed to have supplies off.
So in order of Supreme Court, page 85.
Now, my lord, kindly take page 85.
No, I could not follow this.
My lord, that is why, my lord, kindly take page 85 now.
85, yes.
My lord, this is an order passed by the Honorable Supreme Court.
Yes.
Kindly take, my lord, page 88.
88, yes.
Yes. Learned Counsel, appearing on behalf of the State Government of West Bengal, submits that both on the basis of the order passed by this court, the State Government has delivered possession of such and such plots in zone such and such to the allottees. He further submits that the allottees of the said plots, if filed proper application for sanction of the plan for construction of the premises over the same would be sanctioned by the State Government within a, where is that?
Page 89, second last paragraph.
Kindly note page 89, second last paragraph. Page 89, second last paragraph.
Yes.
Hence, it is directed that these 231 allottees would shift their industries at the site where they are allotted the plots before 28 February 2002, close down their existing units at the place where they are functioning at present.
According to you, they could not have run the
Yes.
factory. Tannery.
They could not have run tannery. Therefore, my lord, this is a factory, my lord, to which, my lord, Factories Act will not apply at all. Here is a case, my lord, they are illegally in operation. My lord, a tannery, because of pollution reasons, my lord, at that point of time, my lord, Supreme Court, my lord, was there, my lord, tanneries were shifted, tanneries was closed, and my lord, there were several, my lord, cases, my lord, umpteen in number, my lord, followed, my lord, by disconnection, challenging disconnection, my lord.
I follow your submissions, but
Lord, this is
how could you say that this runs for 30 days?
This is, my lord, because the consumer, my lord, except for word of mouth, saying that it runs for 20 days, my lord, it could have said it runs for 1 day only. It could have said it is closed absolutely, my lord. It is for me that I found out that no, it is closed, supposed to be closed, still running. But I found that 10 hours.
Not disputed that.
No, my lord, I have said, according to me, it is running for 365 days. Lord, I have not accepted. Lord, in my page 51, I showed it to your lordship.
Page 51. No, that is your calculation.
My final order of assessment, I say that my engineer's report says that it is 365.
Page 51.
It is a part of my final order of assessment.
Mr. Rai, this is not on the basis of the engineer. This is on assumption. Is taken as 365.
Yes, it is taken.
So you are assuming.
Yes, why, my lord?
So because that is, Mr. Rai, that is, since in the statute it has been made 1 year, you are converting it to days. You are so there is no positive report of the engineer who has found on some evidence it is running on.
That is exactly the point, Lord. If the engineer is not able to find out positively, then, my lord, this is which on, my lord,
not
this is the
365, 12 months.
12 months is 365 days.
That is That is a matter to be decided.
Yes.
Whether 12 months is 365 days.
Yes, yes,
Or it will be 240 in a particular case.
Yes.
That is the matter
Now,
to
my
be
lord, what
considered.
will be the basis? My lord, whether it will be 365.
Ordinary cases, yes. 1 year, 365 days,
Yes.
if you convert.
Here, my lord.
So far as this abstraction of
Then, my lord,
electricity.
here in this case, we will have to accept, my lord, as sacrosanct what has been submitted by the consumer.
Now,
It
Mr.
is only
Rai,
then.
let us take an hypothetical
Yes.
example. You find that in a given case, an unit runs for 25 days a month. How we will calculate?
25 days, I'll take 25 days into number.
25 into 12.
Yes, yes.
So it's but statute says 12 months.
Yes,
So,
if it is ascertainable, my lord, if it is not ascertainable.
ascertainable, there are two things. Ascertainable is for how much period? It may be 3 months. You could not ascertain whether it is for 3 months, for 6 months, or
My lord, ascertainable
then-
extends to both. My lord, to the extent, my lord, in days, and to every unit of time, my lord, will be the best way to put it. Ascertainable length of time. My lord, it may be minutes, it may be hours, it may be days, it may be months and year. If it is said, if the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place.
Which
And if,
section you are
however,
placing? Which section? 126?
5.
5, yes.
If the assessing officer reaches to the conclusion that unauthorized use of electricity has taken place, the assessment shall be made for the entire period during which such unauthorized use of electricity has taken place. And if, however, the period during which such unauthorized use of electricity has taken place cannot be ascertained, such period shall be limited to a period of 12 months immediately preceding the date of inspection. Now, it's a period. It's not only months or days or, my lord, year. The period, my lord, that would be covered under 12 months. Now, my lord, it could be several months under 12 months. It could be, my lord, several hours under 12 months. It depends on what unit of time, my lord, we are taking to, my lord, reach a conclusion.
So according to you, if there is no definite evidence,
Yes.
then it is to be taken as 365 days.
It's a penal
If-
provision.
Yes, if it is a definite information is available, then that is your submission.
That is it. That is it. That is it. And here, my lord, in any case, my lord, if the appellate authority found that it was 20 hours or 20 days per month, my lord, what is the justification for the appellate authorities arriving at such conclusion? My lord, the appellate authority abruptly reaches the conclusion. My lord, it records
on the basis of the submission.
Therefore, my lord, that is all. My lord,
You have not controverted that.
my lord, I have made my submissions. I have made my submissions that it is kindly have a look, my lord.
Mr. Rai, this was before the authority, before the final order of assessment. Show me the submission of the consumer before the
appellate authority.
No, not the appellate authority.
Before us.
Before the final order, at the time when the final order of assessment.
Yes, your lordship will
was
kindly take.
Show me the SSC submission there.
SSC submission এখানে আছে না না ওর রিটেন সাবমিশন এখানে আমরা অ্যানেক্স করি না রিটেন অবজেকশনটা লেখা আছে পেজ 50 ওটা তো মিস করে লেখা আছে পুরোটা কিভাবে পেজ 60 My lord, it's extracted in the final order of assessment, but my lord, the entirety of it, my lord, I think it's
only
not.
that part. I am with the regard to this.
Very well. Kindly take, my lord, page 51.
Yes. Which portion deals with that period?
Kindly take, my lord, page 52, paragraph 5. Page 52, top
I'm
paragraph.
at that.
Yes.
Well,
So I
page
have gone-
70. Page 70, your lordship can
I
have
have
a
gone-
consumers.
I have gone through carefully and consumption pattern of the consumer against K rate meter and observed registration of such and such units in the month of October 7. Another K rate industrial meter number such and such, the same period registered a consumption unit of such and such. The total units consumed on the period is such and such. As per the submission of the consumer, the factory operates for 6 hours a day, 20 days a month. This depicts a load of 13 kilowatt. My lord, this is how, my lord, the assessing officer deals with this. 13 kilowatt against meter number such and such, and 2.3 kilowatt against meter number such and such. Thus, the total connected load of the installation amounts to 15.3 kilowatt as per the written representation of the consumer. However, the exact connected load could not be ascertained since the consumption was recorded through a tampered K-rate industrial meter number such and such.
Second last paragraph.
What is the finding here with regard to the number of days?
My lord, number of days is that is that one line, my lord, which I showed.
No, that was from the engineer's report. After considering that, what is the observation at the time of final order of assessment?
My lord, he takes it at 365 only, my lord, page 54.
365, Mr. Rai, is not the finding.
365 days into 10 hours.
365, he has quoted the information gathered from the report of the engineer. But after considering, and there is a submission of the consumer, what is his conclusion? He may have accepted the evidence, may not have accepted the evidence. What is the finding? Because that is the recording as per the report, what the report says. But what is the assessing officer finally deciding on the number of days? I think subject to correction, no finding on that. Either accepting, no, I reject the contention of the consumer, it is 30 days. That sub finding is not there.
Kindly see, my lord, page 53, last paragraph.
53, last paragraph, yes.
After visiting the above factory premises, I am in the definite opinion that the establishment was engaged in the business of tannery, which was running in full swing prior to disconnection of the services on 8th April 08.
But how many days in a month? No finding on this. Evidence are there.
My lord, last
evidence is there, another submission is there, but no concrete finding on that.
My lord, last paragraph, my lord, last page, my lord, where he does the calculation, he takes his, my lord, for the period in question, he build units for the period in question, my lord, he writes.
Yes, Mr. Rai, he takes 365, but prior to that, he does not come to a definite conclusion. I am rejecting this, I am accepting that.
My lord, he will not write it, my lord, in the way of a judgment.
No, not that.
My lord,
because
they are engineers, my lord.
Not that. Mr. Rai, there are two evidences. One is report of that he has quoted in the first portion which you have shown. One is that evidence. Another is the submission of the petitioner. So he has to accept either of that, and he has to give reasons why he is accepting. Reasons are to be there. Not a question of writing a judgment. No, I am not relying upon this. I have to rely upon this. That's
Lord, he has not.
That finding is not there.
He has not written it, my lord, in that black and white, my lord, that, but it ultimately boils down to it only, my lord, because he has accepted 365 days. Statute says if the reason is unascertainable. My lord, this is a case of theft of electricity. Lordship will kindly look at this, my lord. My lord, the lordship will not test it, my lord, on the anvil, my lord, of that, my lord, high a test, my lord, where your lordship, my lord, assesses, my lord, quasi-judicial authority order.
Yes.
My lord, administrative authority, engineers, my lord, even English, my lord. I had heard it, my lord, from this court only, Justice Bhaskar Bhattacharya, my lord, while he was sitting in division, he said, my lord, we'll have to give them that leverage, my lord.
No, because I'm not on language.
My lord, I understand. My lord, it would have been, my lord, the best thing to do, but not from the tenor of the order, it appears.
Since he has taken this 365, you have accepted.
And my lord, he says, the period in question, my lord, he has tried to, my lord, put it, my lord, kindly look at page 54 again, build units, my lord, in bracket, my lord, he writes period in question. My lord, he wanted to, my lord, convey it to, my lord, to the intelligence of the reader, my lord, that it is unascertainable.
Perhaps what swayed in the mind of the assessing officer was he has converted 12 months into 365 days.
Yes, that he has done.
Report of the engineer was also so. And he has also.
That is usually done, Lord. In fact, Lord, they go a step higher and they multiply it by 24 to be on the safer side. Lord, there will be no dispute then. I have not been able to, my lord, ascertain the period. I have.
No, but here is the case you have on inspection found it is running for 10 years.
10 hours.
For 10 hours.
Done that. I have
So
done
the
that.
authority will
They have
act
done that.
accordingly. So
Yes,
they will
yes.
not,
My lord, it
when
says-
they find 10 hours, they will not say 24 hours.
No. They have found 10 hours. They have set 10 hours, and my lord, they have because
that much reliance can be placed on the authorities.
Yes,
that
yes,
they will
my lord, they have done that.
when they are found on records that it's
My lord,
running for
here, my lord, he simply accepts that. My lord, he also, my lord, in no true sense, my lord says that the assessing officer's reasoning is wrong.
But there are two evidence available. One is of the report and another is of the submission.
He is only submission, no evidence.
Yes. And the appellate authority accepts that.
And my lord, the appellate
How can the writ court interfere with
kindly,
that?
kindly look at this. My lord, kindly look at this. First is, my lord, the consumer's submission in respect of a factory which could not have been running at all. My lord, kindly take this into consideration, my lord, because while my lord, even taking 10 hours and 240 days, we are giving leverage to a consumer, my lord, who is in the teeth of the order of the Honorable Supreme Court. My lord, this
Mr. Rai, that is another thing.
Your lordship,
Highlighting, you can haul him up in contempt.
Your lordship
Or
will
violation of the Factories Act. 30
there.
days.
That's
you can
there.
haul him up
Here also,
anywhere.
my lord. Here also, my lord. Every loss of a paisa, my lord, of electricity, my lord, we will have to bear. My lord, we will have to bear. The normal people have to bear. My lord, because that will be written off. It will become bad debts. It will form a part of the tariff later on, my lord, and all of us, my lord, will have to bear it up, my lord, in the form of increase. So why not the person, my lord, who has committed the illegality? He has accepted the illegality. He says, I have done it lesser. My lord, that is the only thing.
Yes, because can he be penalized for an amount for which he could not have been?
But he has only paid lip service.
But that the entire thing goes.
No, my lord, he has only
Have
paid
to pay, but
has-
how much?
My lord,
That
he
is
has
the
only paid
question.
lip service. My lord, because he says it's only hearsay. He says, no. 10 hours, 20 hours. My lord, it was his onus to prove. My lord, because statute gives me liberty. If it cannot be ascertained, 365. Therefore, my lord, if I am to, my lord, fall back upon the statute, it was, my lord, for the consumer to bring up the evidences. My lord, accepting for his submission, there is nothing more on record. And my lord, your lordship will kindly, my lord, kindly permit me, my lord, to put this submission of mine, my lord, in the form of a question. Was it justified, my lord, on the part of the appellate authority to accept the submission of the consumer, my lord, as gospel truth and do away with the
They are also they are not bound to write a judgments in that.
Yes.
He found that is acceptable.
My lord,
this will find from the ultimate conclusion he has accepted that.
Yes,
Why
but
he has
only-
accepted, the assessing officer, why he has rejected, that reason is not there. Appellate authority, similarly, he is silent on that. Why is accepting the consumers?
Assessing officer, my
I am
lord,
borrowing your submission.
yes, I know, my lord. Assessing officer is justified at least in terms of the section. My lord, appellate authority is not. Assessing officers, my lord, I can stand here, my lord, and I can justify assessing officers.
The right, do you have any authority to show if the period cannot be ascertained? It has to be 365 days. I am not on 12 months.
No, my lord, I have an authority to show that, my lord, what has been written in the statute, not only that should be considered.
12 months, Mr. Rai, that there is no dispute. But whether this 12 months is to be construed to be 365 days or has to be on if the evidence is available.
My lord, there is a judgment of our court.
Total contracted load kilowatt or contracted উপরে নেওয়া হবে এই KW
এটাতে ছিল না আগে?
না এটাতে ছিল না
In this formula,
এখানে তোমার
what it says, it does not say days.
no considered or 12 months as applicable in terms.
Period in hours. Hour, my lord, if you have to if your lordship has to convert years into hours, year into hours, it has to be year into months. Months will have to be converted into days.
Or,
Days will have to be
or
converted
Mr.
into
Rai, you can have it converted hours in a month also.
But that has to be multiplied only by number of days then.
Hours in a month. You can also have evidences hours in a month. Because that will again boil down to number of working days.
Yes. But not here.
In a
there is
month.
no evidence. There is no evidence. It's this only submission. It is only submission.
Then let him produce the evidences before the appellate authority.
Let him produce. Let him produce. That has to be there. That has to be there. He ought to have done it. না পেলে না পাবে কিন্তু প্রডিউস তো করতে হবে।
let the appellate authority decide that.
Yes, yes. Should have been. Lord, my quarrel was only this, Lord, because by a whip, my lord, of the appellate authority saying no, it should be because he has said so. My lord, that will be very dangerous. He ought to have reached a conclusion on his own then. He is the appellate authority.
What should be done? The petitioner is, or not the petitioner, I should say the consumer is not here. Because even if I remand it, it has to be set aside. An order which is in his favor. What should be done?
The appellate authority's order has to be set aside, my lord.
Then the consumer
has to be heard.
Has to be heard. In his absence, what you are saying, Mr. Rai, on policy, what is the amount, the difference will be? This 365 and 240?
Difference, my lord, I don't think will be much. But
because policy, Mr. Rai is right. Policy says 12 months. So you are on the policy that it will affect your, may not affect your, because in this, it's only how many days or hours they were working in a month. Whether it was 30 days or 20.
No, my lord,
20.
in this sense,
that is on the evidence.
Yes.
Nothing on policy. It has said nothing on policy.
In that sense also, my lord, suppose, my lord, my inquiry officer's report is there, which is in the form of evidence. That has been.
No, I'm not on merits. If you are saying that it has affected my policy decision, it will not affect your policy decision.
Yes,
it may be on the merits of a case. So what will be the amount?
Amount won't be much. Amount won't
Why
be
are you
much.
fighting for this?
Lord, since we have come up, my lord, lordship will not leave me, my lord, without.
No. That is a different thing. I can, because again remanding, this is a matter of 2009, again a challenge. Whoever wins.
My lord,
That is the thing. What is the
lord,
amount? If you can take instructions, I can adjourn this.
I'll take it.
Because since you are appearing for the authority, without instructions, don't make any submission. Because you have made your submissions, try, give a notice. If that is there, because unnecessarily again remanding, it has to be remanded. What you have submitted, evidence, 2009 matter, again it will go back, again another round of litigation. If the amount, I think you must have spent much more than that. So, Ashwin. Mr. Rai, learned advocate, appearing for the petitioner, submits that the appellate authority, while setting aside the final order of assessment dated 5th of May 2008, has accepted the submission of the consumer that the factory operated only for 20 days a month. 6 hours they have not accepted.
No, that there also, my lord, they have, instead of 10 hours, they have
6 and 10.
6 and 10.
কি বললাম? Month and for 6 hours per day, in the absence of any evidence being produced by the consumer in that regard. Yes, Mr. Rai, that is your submission. Full stop. None appears for the consumer. Consumer is the third respondent.
Yes.
None appears for the consumer / third respondent. Full stop. The appellate authority / the respondent number 1 is represented by its learned advocate. The learned advocate on record of the petitioner is directed to communicate the next date of hearing to the learned advocate for the third respondent. Friday? Friday. Can take instructions. Friday রেখে দিন. Continuing matter. Yes, call the next matter.
Grateful.
Take it back.
80.
I appear for the respond this matter, my lord. I'm filing my opposition.
80 am for the petitioner, my lord.
Let it be done.
Regulation.
करिएगा.
Take it back, you will bring on the next day. Otherwise, you have to give both, book as well as that. Choice is yours. Yes.
80, I'm for the petition about conference for the.
I'm filing.
You are filing your opposition.
I've already filed, my lord.
You have filed your reply.
I filed my reply, my lord.
What is this matter?
The issue is
Long matter, short matter?
it's a short, not it's a
Short.
mediocre matter. Not only not long, not short, mediocre. You are covered by judgment of this honorable court, my lord. It has been modified in appeal. And that in the
No, I could not follow.
suo motu, my lord, accepting the coverage, my lord, of the Provident Fund, and I was directed to pay the dues, Provident Fund dues, or the pre-discovery period within the time stipulated in the coverage letter. I paid that, and prior to 19th of February 2009, because I was covered by the earlier circular where it has stated if I pay the dues within the time stipulated in the coverage letter, then I have to pay only the interest under section 7Q, and damages is being waived. But my lord, the Provident Fund Authority, my lord, issued a notice that I have to pay both the interest and damages. I paid that interest part, and I've challenged that impugned order with regard to the damages.
Damages.
Because I within that period prior to the issuance of the next circular. In the subsequent circular, it has been stated that it is a
Where is that subsequent circular?
And at page
Page 61, Lordship, can it take some?
61. Yes.
But it is
Page 61,
but at page 64 is the earlier circular.
64.
64 is the earlier circular. And
yes, that has been withdrawn.
That has been withdrawn by by
61, page 61.
Page 61 by the circular, earlier circular is withdrawn prospectively.
Yes.
Prospectively with the effect from
16 to 2009.
Exactly. And developers.
Yes.
This is my case, my lord. And I have paid the entire dues with regard to pre-discovery period as stipulated in the coverage letter within the time stipulated in the coverage letter. That will show.
Yes, Mr. Prasad.
My lord, here, this my learned friend wants to take benefit of the from this circular, but that circular was not in force. That circular was already withdrawn by the department, and more so, my lord, I can come with recently Justice Rajsekhar Mantha, my lord, while sitting in the division bench recently, my lord, has passed the order that damages will be levied to the pre-discovery period also. Recently, we got this judgment.
Give a copy to your learned friend
so that I have not appeared.
No.
By Monday, I can give you.
So you give it to him so that he can.
My point is that I am covered by this.
Not more so, my lord.
He says the division bench has considered that issue.
Yes, that is so, yes, that's what I'm saying.
Then I am bound by that.
I have also the division bench in my case also.
All right, so you share the judgment amongst yourself.
He is there. He was there in that judgment also.
Share the judgment. You will also give that judgment.
Record an order, can you keep it?
And if there are two conflicting division bench, it has to be referred then.
Yes, I can. That's what I'm saying.
Two conflicting division bench.
Not conflicting, Lord.
He says
no. Justice. That was Justice.
All right, Justice Sanjeev Banerjee and Justice Chandra.
Heard the learned advocates for the parties. When next week?
Next week, Lord.
This matter in the next week.
Next week, Lord, Monday.
Under this same heading. Affidavit in opposition filed in court today is taken on record.
Yes, yes. I filed my reply, my lord.
Reply was filed earlier.
So kindly record that.
25th of April.
No, they can in reply to the record. They can in.
I have already filed my reply, my lord.
Grateful.